Yes.
My lord, with the consent of the other side, I'd like to mention item number 17 and 19, my lord. The hearing matters, my lord. Uh, I don't have the instruction whether the respondents whom I'm representing are in. Lordship, may grant me 2 weeks time. In the meantime, I will get the instruction.
2016 matter, Mr. Counselor.
My lord, last time they had taken the brief from me, but they have not contacted me. So, my lord, one chance to get in touch with them.
You
Because,
get in touch with them, you come and
unfortunately, my
fetch
lord,
it.
I do not have their phone numbers. My lord. And the person
Then
retired in
if you don't
2000.
have their phone
Lordship, may
number,
grant me at least 7 days time, my lord,
how are you going to contact them?
to the union officials.
Mr.
S. Chakrabarti for the
S.
response
Chakrabarti for the respondent number 2
in both the items.
submits that the respondent number 2 has taken away the brief from him. And as such, he does not know and as such, he does not know. So if he's taking away the brief,
My
then what
lord,
happened?
whether in the meantime they have expired because this person retired in 2012 and it is 10 years.
No, no, Mr. Counselor, once the brief has been taken away from you, what role do you have to play? What is the interest in the case?
They did not get back to me. My lordship, 7 days time. In the meantime, my lord, I will get the instruction whether they are willing to pursue this matter. Because,
When did they take away the brief from you?
my lord, 2022.
22.
And this matter has not come after it was listed. This is the
Okay.
second time it has.
It has taken away the brief from him in the year 22. He accordingly pays for time to obtain instruction. List the matter on, give a date. Monday. No. Monday.
Fifth.
5th. Okay, 5th.
And so far, item number 19 is concerned, my lord, this matter was substantially heard before Justice A.D. Chaudhary, my lord.
Okay.
Item number 19.
Item 19.
Though it is not shown as part heard, but it was substantially heard.
Okay, Mr.
I'm for the petitioner, S. Chakrabarti.
S. Chakrabarti, Learned Counsel for the petitioners, submits that the matter was substantially heard by the Honorable Justice Mr. A.D. by the Court of the Honorable Court by Honorable Mr. A.D. Justice A.D. Chaudhary. He accordingly prays that the matter may be adjourned. Good for the other side.
I will inform, my lord.
Accordingly, release this matter after 2 weeks.
Before the appropriate.
I won't say anything.
Right, please, Your Lordship. Lordship, prayer for listing. The matters are here regarding settlement of fisheries. Last listed on 5/4/24. So the matters may come on 25/10. Coming Friday.
Why? What is the matter about?
Settlement of fisheries.
New matter, old matter, what?
New matter.
New matter.
So there is stay order.
If there's stay order, there cannot be a new matter, madam.
New Lordship 24 matter. Lordship 2024 matter.
It's not a new matter, it's an old matter. Whether it's one
Yes,
day old, it's still old. Has it been listed before the court earlier?
Yes.
If it's listed before the court earlier, it's not a new matter. Okay.
Perfect.
May I please also? May I please also? My lord, I beg to mention item number 11 and 12, my lord.
Yes.
This matter is second week of November. My lord, my senior is out of his due to medical purpose, my lord. Right. Second week of October, my lord. He's coming first week of November, my lord.
Is there a stay order
No, my lord.
on the prayer for adjournment made on behalf of Mr.?
Hi, hello, my lord. My name is Dr. My lord T. Sheikh.
No, on the prayer for adjournment by Mr. T. Sheikh, and counsel for the petitioner. This is the matter after 2 weeks.
Okay.
Lordship, I may be allowed to move on petition for motion. The matter is about the distribution of some agricultural equipment. And I have challenged the in violation of the rule, the agricultural equipment.
When?
On 25th, Lordship. Of like.
May I please, Your Lordship, I beg to mention item number 5, 6, and 7.
Yes.
My senior is not well today.
Huh?
My senior is not well today.
I am appearing for the respondent lawsuit for the private respondent in 5, 6, and 7.
Not well today. Who is the senior?
He Borgo.
D. Burgoyne. That is only in one case. What about in what in
Concerned with the other.
huh?
Concerned with the other.
In serial number 5, is he there? He's not there, his name is not here.
Taken, consent has already been taken, he's submitting now.
You see, it's not a question of consent being taken. It's a question of informing the court 1 day in advance. There is a notification issued by this High Court that you want to adjourn a matter, please submit an application. There's a form. Otherwise, what happens is we read the case. We are wasting our time. Why should I allow you when it's not in when it's not in conformity with the notification issued by the High Court? Settlement of fishery has been challenged. What case do you have?
They are the highest bidder, lordship, and settlement has been made with me, lordship.
So what is the case? What is the ground of challenge? That since you are the highest bidder, you should be given. Correct. Who is for the fishery? Yes, so why haven't you given it to the petitioner? Huh? Where is he? See, you wait. We'll see. You wait. If you adjourn everything, then there'll be nothing left. You wait. Yes, next.
I'm playing for listing of motion, madam. Tomorrow, day after tomorrow, in declares.
Is it a new motion
Motion, madam.
tomorrow?
Of like that.
May it please the lordship, I recommend item number 23 of the delegates.
Yes,
Chairman's it was submitted.
okay, right. On the prayer for adjournment made on behalf of Mr.
B. Sharma. On behalf of Dr. Asuma.
Huh?
B. Sharma on behalf of Dr. Ishra.
Both the names are not here.
My lord, we have been appearing in this matter, my lord,
For whom?
for the petitioner, my lord.
Petitioner's council name is only SK Kejriwal in this thing.
My lord, we have been appearing in this matter.
As a wakalat nama there.
But it,
Give me item 23.
my lord, learned counsel is.
You're not there. How come the cause this has? Huh? Where is the wakalat nama?
Wakalatnama perhaps not filed, but we have been appearing in this matter. since-
Sorry, Mr. Council. If there's no one to, if there's no council, how can you appear? Sorry. Is there any wakalat nama? There's no wakalat nama. Right. Adjournment prayer has been made on behalf of Dr. A. Saraf. Pustab. By Mr.
B. Sharma.
B. Sharma. Pustab. It is noticed that there is no wakalat nama executed by the petitioners, by the petitioner in favor of Mr. B. Sharma or Dr. A. Sharma. The only name showing the counsel for the petitioner is Mr. S.K. Kejriwal. However, Mr. S.K. Kejriwal. No, S.K. Kejriwal and Miss S. Kejriwal. However, Mr. S.K. Kejriwal submits that the brief has been taken away from him and Miss S. Kejriwal by the petitioner. And the petitioner has apparently engaged the petitioner. Engaged Mr.
B. Sharma or
B. Sharma and Dr. A. Sharma. However, there is no wakalat nama executed in favor of the above two counsels. Accordingly, this court does not find any reason as to why the prayer for adjournment should be allowed in Pusta.
My lord, there is no dispute that my
However, as a last chance, Mr. B. Sharma shall submit a wakalatnama executed by the petitioner in his favor within a week from today. List the matter. after a week. You submit a wakalat number.
Obligement,
How can you do this?
obligement. Well, interim.
You file it first. You file a wakalat number. I'm not hearing you.
Lordship, may I pray for item number 3, Your Lordship?
Huh?
Item number 3, Your Lordship. In this matter, we are supposed to file a reply to the affidavit in opposition, Your Lordship.
No adjournment.
Your Lordship, due to some miscommunication, Your
No
Lordship.
adjournment, Mr. Counsel. If you don't understand the meaning, that's okay.
Lordship, on the date we mentioned item number 9, Lordship. For a week, Lordship. I have taken consider with our side, Lord.
You mean that item 9?
Lordship, yes. Lordship, in fact, Lordship, the matter relates to payment of the contractual dues, Lordship, and the process is on, Lordship, and it will go to the finance department by a week, Lordship. This is the instruction I am having, Lordship. So I paid for a 1 week time. Let it be listed after 1 week, Lord.
That is what you said last time also. That is what you said last month.
No, Lordship, it is before the government now. Government now, it is under process to send it to the, due to the holidays and all, Lordship.
Mr. Counsel, have you sent it to the finance department?
Lordship, they are, by today or tomorrow, they are sending, Lordship. That is the instruction I am having, Lord.
Then we list it on Thursday.
Thursday or Friday, Lordship.
Huh?
Friday or Monday, Lordship. Monday. Lordship, will list it Monday.
Mr. N. Upadhyay, Learned Counsel for the respondent submits that the Irrigation Department Secretariat shall send the proposal for sanction of the contractual dues of the petitioner to the Finance Department within 2 days. Full stop. This court finds that a similar submission had been made by Mr. N. Upadhyay as recorded in the order dated 16/9/2024. More than 1.5 months have passed since then. Full stop.
25 minutes. No,
Just say more than a month has passed since then. Full stop. As a last chance, comma, the Irrigation Department Secretariat should send the proposal for sanction of the amount to the Finance Department by the next date, comma, failing which the personal appearance of the Chief Engineer, Irrigation Department, and the Secretary to the Government of Assam, Commissioner Secretary to the Government of Assam, Irrigation Department, may be called for. This is the matter on Monday.
apply. Apply.
Supplementary motion, item 24.
Malak, in this matter, Malak, senior advocate Mr. K. M. Sudhir is a case, Malak, these all makes, Malak, can be taken up after some time, Malak. That's Malak.
Item 1 and 2 for admission.
Made clear. So by these two petitions, the petitioner has assailed the jurisdictional error committed by the assessing officer in undertaking and completing the assessment proceeding, even in the absence of any jurisdictional facts connected the petitioner with any unauthorized use of electricity. The issue for consideration before your lords is there, whether extension of load simpliciter amounts to unauthorized use of electricity within the meaning of section 126 of the
Extension of load.
simpliciter, only extension of load without there being any actual use,
Extension of load simpliciter
without there being any actual use.
without there be any actual use. Yes,
Amounts to unauthorized use of electricity within the meaning of section 126.
amounts to
Unauthorized use of electricity
use of electricity
within the meaning of section 126 of the electricity.
yeah.
Your lordship may kindly take up item number 2, my lord. Pleadings are complete in that case. my lord. Affidavit and affidavit in reply have been filed. Lord, what happened in this case, my lord? An inspection was conducted.
What was the undertaken?
Inspection,
Inspection.
yes,
Inspection undertaken when?
on 25/5/16, my lord.
25/5/16.
Yes, my lord. That your lordship will find it in Annexure 6, page 53 to 62.
Page 50.
3 to 62.
Yes.
Your lordship may kindly come to left-hand side column E. Connected load is shown at 831 kilowatt, my lord.
E.
831 kilowatt, connected load.
No, this is Annexure 6.
Annexure 6, page 53.
Yes, I've got it.
Your lordship will find serial number 1, consumer particular.
Yes.
Serial number E.
Yes.
Connected load is 831 kilowatt.
$831.
And the transformer capacity is 1000 kVA. Which is equivalent to 850 kilowatt, mil.
Equivalent to 850.
50 kilowatt. Yes, mil. Because this can be converted by multiplying or dividing by.
But
or-
your connected load is 831
Yes, mil.
or 851.
831.
831. So this is equivalent to 850
No, the
kilowatt. This
transformer capacity,
transformer capacity is 1000 kVA,
which is equivalent to 850 kilowatt.
equivalent to
850 kilowatt.
correct.
Now, my lord, if I exceed the connected load, then I may be subjected to penal liability within the meaning of section 130, 126.
If you exceed,
The connected load by 831 kilowatt.
liable under one section 26.
126.
Yes.
My lord, here, one more issue, my lord. The contract demand, because as per the provision of the schedule of tariff, the petitioner is given an option to enter into contract related demand, which will be to the extent of 65% to 105%.
What do you mean by contract related demand?
Contract demand is, my lord, the demand for which the petitioner enters into an agreement with the supplier, so that they will make ready the supply for which the contract is. And
But your load is 831 anyway.
Yes.
Then
as per the schedule of tariff, I can enter into a contract related demand to the extent of 65% to 105% of my connected load.
as per schedule of tariff.
Schedule, my lord, your lordship will, it will be convenient, take up the provision. Obviously.
Contract related demand can be made up to how much?
From 65% to 105% of the connected load
From 65%
to
to
105%.
105% of the connected load.
Connected. Your lordship may kindly come to page 21 of the booklet, my lord.
So that means you can take more than your connected load.
Yes, ma'am. That provision, your lordship may kindly come to page 21 of the booklet.
Yes,
Close C, my lord.
yes.
Contract demand. The contract demand shall be between 65% to 105% as declared by the consumer of the connected load. Converted to KVA by multiplying the same at 0.85 power factor. In case declaration option is not made by the consumer, within the stipulated time, 100% of the connected load converted to KVA shall be the contracted demand. Contract demand for off-season shall be minimum 40% of the seasonal contract demand. Now, my lord, may kindly
Just a
come.
minute, just a minute. Okay, now this 831 kilowatt, the kilo, what is it called? Kilowatt. This is equivalent to how many kVA?
This is equivalent to 491.76 kVA.
How can it
Sorry,
be?
Milord.
How
This
can
is
it be?
978 kVA.
Okay, so
Now your lordship may kindly take close E, page 21.
yes,
Overall penalty.
yes,
If the recorded demand is higher than the contracted demand in a month, then fixed charge based on the contracted demand shall be levied at 3 times the normal rate for the portion of the demand exceeding the contract demand.
correct.
Now, my lord, as far as this petitioner is concerned, my lord, the petitioner entered into a contract related demand of 783 kVA.
Contract related demand of 783
kVA.
kVA.
So,
Though his transformer capacity was 1000. So,
and connected load was 831.
connected load was 831. So the connected load and kVA in both are same.
No,
In both the writ petitions.
this can be multiplied by,
In both the writ petition,
yes, yes.
it is the same.
No,
This-
contract load was different.
Okay, out here
Load is
different than
different.
that.
Load is different.
Okay, out here the contract related demand was 783.
Yes, ma'am.
783 kVA,
kVA,
which is equivalent to
which is equivalent to my lord.
how many kilowatt?
Otherwise, he has come against an order of final assessment by the assessing officer.
Ah,
He has a remedy under section 127.
My lord, these issues were taken by him before the another learned single judge, and the matter was heard on merit on 3 dates, my lord. The dates are
That is a-
7/8/24.
Unfortunately, my learned friend is making a very wrong statement.
No, my lord, this
This
matter,
issue
your lord,
was-
no, another thing, I'll tell you one thing. Now that judge, that learned single judge, the coordinate bench has released the matter from
yes, my
Pathak.
lord, that is why I am arguing, my lord.
So that is why he might have a case that it should go before the appellate
Yes,
authority.
Then also your lordship will like to decide the jurisdictional error, issue pertaining to jurisdictional error.
We will
That
see.
is-
No,
because
but
that
I
is-
just wanted to know this aspect because the way he started out, it appeared that this was a question of law.
Yes, my lord.
I don't
Pure
know
and
if
simple
it's
a
a-
question of law, my lord.
Whether is it a question of law or a question of fact?
It's a question of fact, your lordship, because the
I will show, my lord, this is the
admitted
question.
position is that he has exceeded his connected load.
Okay.
I will
That
show.
is not in dispute.
Ah,
He is saying that even though he's exceeded his connected load, he should not be penalized under 126. Now, the division bench of this honorable court has held that even issues of due process, whether he should be penalized or not, the appellate authority under 127 is competent to decide to it.
okay.
There is a division bench.
So his case is that he cannot be penalized under section 126.
That is this.
So he should be penalized under what provision? Or he should not be penalized at all?
Your lordship, I will take straightforward to page 66. Their own bill, which will show on the date of inspection, my maximum demand was 783. That is within the contracted demand. So there cannot be any question of petitioner exceeding any.
No, then what did the final assessing officer say to this aspect? What was his finding?
His finding is that extension of load, petitioner was found extending the connected load. This is the finding below. That cannot be because under section 126, it is the unauthorized user of electricity which is made penal. Actual user, he must show from the bill because meter records each and every consumption. Your lordship is aware.
No, I'm not aware of anything.
Your lordship is aware. Whatever electricity we consume, that will be reflected in the meter. So this will be reflected from the meter, and I will place their own authorities 3 judgments, my lord. I have annexed, my lord, those 3 judgments in the booklet itself. That shows that only if the meter load is found exceeding, then and then the petitioner can be subjected to penal action under section 126. There are 3 judgments. I have annexed.
Anyway, let us, yes, so the contract related demand for this petitioner was 783 kVA,
KVA.
which is equivalent to how much kilowatt?
My lord, 665.
Yes, then. Now let us go to the, what else?
Now your lordship may kindly come to page 57
Page 57 of the writ petition.
of the writ petition. The inspecting team simply noted down the ratings of various energy consuming apparatus which were available in the petitioner's premises. Whether those were connected with the generator set or with the
Oh, you had a lot of, what did you have? You had a lot of, what
Yes.
sets?
generator set, they have given permission to install generator set. They have also given the permission to use changeover switching arrangement, because if the loads are in two sides, I can use one side of the load. So one side of the load will be treated as my connected load, because for that permission is required, and that permission I have annexed in the writ petition. Now your lordship may kindly see page 57.
Yeah.
As per discussion in the last paragraph.
Yes,
Yes.
yes.
In the revenue meeting held on such and such in the office of such and such, the load survey of the above consumer is verified and found the load is connected with the FHCL electrical network. Total load found to be such and such. Total equal to 1507 kilowatt against connected load of 831 kilowatt. So excess load detected 676. So the content, the finding is that the connected load was found exceeding 676 kilowatt. There is no finding that the petitioner was found indulging in any unauthorized use of electricity.
No, the fact of the matter is, your contract related demand for electricity was 783, which is equivalent to 665
Yes,
kilowatt. Now, total, so the total, what is this, equal to 1507 kW.
kilowatt.
So kilowatt.
Yes.
So you are actually only entitled to 665, but you are being given, you have consumed 1507.
No, there is no finding that I have found consuming, because
No,
Eight-
but how did, they must have looked at the meter. This,
your lordship may kindly come to page 66. That is the bill issued for the month of the inspection, my lord.
uh,
Your lordship may kindly,
no, okay, this page 57 is for which month?
this is prepared on 25/5/16.
Page 57 is for 25, 5,
5/16.
16.
And your
From
lordship, may-
where do you get that 25, 5, 16? Okay, on top. Okay, then
now your lordship may kindly come to page 66.
page 66, yes.
This is a bill dated 9/6/2016,
9, 6, 16, yes.
covering the period from 1/5/2016 to 31/5/16
1, 5, 16.
to 31/5/16,
Hmm.
which includes the date of inspection.
Which it will be.
Now your lordship may kindly see MDKVA in the middle below, meter reading details.
In meter reading details, yes.
Your lordship will find RDKVA 0.5 to MDKVA.
RD KVA 0.52. What is RD?
Running bill,
Running
demand,
demand and
and this is MD maximum demand KVA,
Ah.
783. So my maximum demand consumed by the petitioner was 783 kilo KVA, which is equivalent to my contract demand.
what is this RD? RD means?
This is running demand, I think. So.
You think so? Cannot
My
help.
learned friend will say. I am not concerned with RD. I am concerned with MD, maximum demand.
No, they might be showing that this is your maximum demand,
Yes, my lord.
but then you have been using more.
This is the maximum demand which is recorded by my meter.
Yes, Mr. KP Pathak, yes. This page 66.
Yes, Doctor.
You see in the middle,
Yes, sir.
in the middle, these meter reading details are there.
Yes, sir.
And below that in bold, there is RD KVA, MD KVA, BD KVA.
BD is billable demand below, which is
Billable.
the agreed consent
And
demand.
MD is.
MD is the maximum demand.
So this is maybe they're showing that this is the maximum load you are allowed to take.
Yes.
And but then there's more.
No, my lord,
Why-
there is a
what I do not
provision.
understand
Your
is-
lordship, there is a provision. There is maximum demand that is defined. This is the largest amount of KVA delivered at the point of supply of the consumer, which is consumed by the consumer during 30 consecutive minutes of a month, my lord. My lord, if during 29 days, 23.5 hours, I consume electricity to the extent of 100 kVA. And during the rest of the month, if I consume electricity to the extent of 110, then my meter will reflect 110, not 100. This will be the highest maximum demand which is used by.
Oh, yes, Mr. Kapatak, listen.
These issues which my learned friend are raising are so technical.
Yes,
There is a
yes.
competent authority,
Yes.
statutory technical authority,
Correct.
who has been established specifically to decide these issues.
Ah.
Why is insisting that these factors?
Because we don't know anything.
No, these are statutory provisions, below.
No.
It has
You
been
see,
held by
no,
Honorable
no,
Apex
Mr.
Court, my lord.
Counsel, Mr. Counsel, please understand. There's no point shouting. Okay? There's no point shouting. It's not going to. So you please listen to what this court is also going to say. Now the issue is this. This meter reading details. Outside says RD KVA. You don't know what it means. MD KVA. You know what it means. BD KVA. You know what it means. Now MD KVA means maximum demand. And billable demand is so these can only be maybe they're saying that this is the standard which can be which has been applied for by you. That means the contract related demand. But this may not be the reading.
Yes.
It cannot be the reading.
My lord, page 21
Oh,
clarifies the position
Because
of the booklet
at
below.
page number 65,
Ah,
that the
65.
bill there, I may be wrong, my understanding is the detected load shows 1772.95 kVA.
Where?
Page number 65, the prior page.
Yes, this is the way for which month?
For the.
Bill
this
date,
period,
date of bill 26/5, due date 10/6.
Lordship will see the handwritten
Just a
portion.
minute, just a minute. 26/5/16. 26/5/16. Is handwritten.
Yes, if he's saying his maximum demand is 783 kVA, but the detected load on the date of inspection,
Is 1172.95
yes,
kV.
yes, your Lordship.
That is what is detected, what is reported at page 57, my lord. This is on the basis one, the kilowatt is converted to kVA.
From where do you get this 1507? At page 57. From where do you get this 1507? Can you call some official of yours? We'll take it up at 2. We'll decide this matter.
Very well,
So this is a small thing.
very well,
Just clarify this aspect at the end of the matter.
very well.
At 2.
Only thing, my lord, clarification is whether the load as LS2 have been detected, that is the
We
meter.
will see, we will see.
Meter load.
Let the official come.
Very well.
If it can be shown that this is the meter load, I will pay.
Look, the problem is that you see, the problem is that we do not know. You are also not sure. So you are one unsure man leading a blind man to decide a case. So let us have an official who knows what the ins and out of this.
That will be better.
Hmm.
Very well.
Then
Obliged.
we might have to send it to the appellate authority also. Or
Okay,
might
great.
decide it here. We'll see. We'll see that
Very well.
at 2.
I think we
I told him not to be, I told him to be here, he's not here. Okay, we'll discuss it. Right. No one appears for the petition on call. Full stop. Though a mention had been made on behalf of the petitioners to adjourn the matter. And when the at the time of mentioning, this court had not agreed to the prayer for the adjournment of the case. However, no one appears for the petitioner when the case is called up. Miss
And Bora,
N. Bora appears for
PNRD department.
the PNRD,
PNRD.
for the PNRD department. Next paragraph. The order dated 30/9/2024 passed by this court is reproduced herein below as follows. Next para, as can be seen from the order dated 30/09/2024. It is the case of the state respondents that there was no record available in the office of the respondents against supply of materials by the petitioner. So neither was there any record of any material bills pending, material bills submitted by the petitioner for which a claim has been made in this writ petition. The above shows that there are disputed questions of fact. Full stop. Next para. The above being said, comma, as no one appears for the petitioners, comma, the writ petition is dismissed for non-prosecution.
Item 4.
May please, Lordship, the matter relates to the non-payment of contractor bills.
Admitted amount.
Lordship,
Where is the admission?
Lordship, PNRD has produced a communication dated 13/12/21, Lordship, on 23/6/2023, Lordship. Lordship, during hearing of the case, Lordship, it came to the notice that finance is a necessary party, Lordship. For that, we have filed an implement,
Okay, your file.
Lordship.
So where is the application?
It is connected with this, Lordship, I 317.
Yes. Because it seems that, yes, you have admitted this amount or what?
Lordship, it's under process, but
No, but where is the admission? Madam, it just says that your bills are included, included,
Lordship.
but it does not specifically state as to the amount that is payable to you.
Lordship, repeated orders have been passed by this honorable court, Lordship, for giving time to PNRD, Lordship, to inform the court about the time frame within which the
Madam,
petitioner-
please understand the question.
Lordship.
Where is the specific admission that they are admitting a specific amount?
Lordship, PNRD has not filed any affidavit in this. And admitting or refuting our,
Who is, not PNRD, State Election Commission has filed.
Lordship.
So they have admitted to how much? What is their claim? How much is their claim?
Total claim was Lordship, 24 lakhs 13,200. Out of which, payable amount is 17 lakhs 27,200. It is pending Lordship. That's- In the affidavit filed by Election Commission Lordship,
Yes.
but admitted amount is Lordship 17 lakhs,
Huh?
17.
Where is that?
They have received some instructions, but
Oh, you have received instruction.
that's it.
Show me your instruction. Okay, anyway, let us come to the IA first.
That's it.
IA, you heard Miss
P. Sharma. Lordship.
P. Sharma, learned counsel for the applicant, who praised that the Commissioner Secretary to the Government of Assam Finance Department should be implemented as respondent number 6 in the writ petition. Mrs.
N. Bora.
N. Bora for the PNRD submits that she has got no objection to the same. The Commissioner Secretary to the Government of Assam Finance Department is accordingly implemented as respondent number 6. Petitioner to submit a corrected copy of the cost title to the registry within
3
3
days.
days. The IA is accordingly allowed and disposed of. Then in the main case, you write, in view of the order dated 22/10/2024, passed in IAC 3176 of 2024, the Commissioner Secretary to the Government of Assam Finance Department is implemented as respondent number 6. Issue notice to the respondent number 6, Mr. A. Chaliha, accept notice on behalf of the respondent number 6. Copy of the writ petition be furnished to Mr. A. Chaliha by the applicants, by the petitioner's counsel during the course of the day. Full stop. Next paragraph. The petitioner's claim is for payment of rupees, how much?
Total bill amount is 24 lakhs 13,000.
Is for rupees 17,27,200. Out of the total bill of
4 lakhs.
24,13,200. It is seen that while the respondent number 2 has submitted an affidavit, respondent number 2 has submitted an affidavit stating that the outstanding liabilities of the petitioner are included in the demand proposal made by the Deputy Commissioner, Bimaji, comma, the exact amount payable to the petitioner has not been stated in the said affidavit. Ms. N. Bora appearing for the PNRD department shall submit affidavit on behalf of the PNRD department stating the exact amount payable by the PNRD department to the petition. The affidavit should be filed within a period of 2 weeks. 2019 matter,
2018 election, that's it,
huh?
not true.
2 weeks. This is the matter. Acha, before that, before that, listen. Miss N. Bora has also submitted a letter, has also submitted letter number, letter dated 12/9/2024, a letter number 548825/DFA/1/727/257/2024 dated 12/9/2024, issued by the Commissioner PNRD Assam, which is to the effect that this is not the letter. Where's the letter? Actually, this is a number, different number, huh? Letter number E-363132/DFA. Okay, you put that letter and this also, and letter number E-363-132/DFA/423/047 dated 26/2/2024, showing the proposed amount payable to the petitioner as rupees 17,13,200. Then the Ms. N. Bora shall submit the affidavit within 2 weeks. This is the matter of two.
These matters are otherwise ready for disposal, but last evening I was informed that there are 3 matters. In item number 5 and 7 I appear. Item number 6, apparently the petitioner's counsel is not well. So that is what otherwise I'm at your lordship's disposal if your lordship wants to take up.
Yes, who is the parent for the fishery? Why was the petitioner not selected?
He is the fourth highest bidder.
Huh?
Fourth highest bidder also.
Fourth highest.
Fourth highest valid bidder. And otherwise, the respondent by the valid bidder, first highest valid bidder.
Your claim is that you are the highest bidder.
No. This case has some amount of history. But what had happened, just to briefly indicate, what had happened was, the petitioner herein has been, as a society, has been in existence for several years, several decades. Now the respondent number 6 society got formed. There was a lot of disputes between these two. Ultimately, the matter went up to Supreme Court. Supreme Court said that the registration of the respondent number 6 was sought to be cancelled. In that connection, the matter went up to Supreme Court. Supreme Court said that its existence cannot be disputed. However, their area of operation needs to be demarcated, taking into consideration the fishery. So ultimately, there was a demarcation done of the fishery itself. It was made into part 1 and part 2 fisheries. In respect of part 2, it was decided that we are in the area of operation, and so far as part 1 is concerned, the respondent number 6 would be in the area of operation. Now, somehow in 2011, it managed to get, we had not participated in that particular tender process. It managed to get the settlement without being in the area of operation. And thereafter, it quoted an exorbitant rate. Not only did it manage to get the settlement, it continued to ask for remissions, it continued to ask for extensions, saying that we are incurring losses and all that. Ultimately, we came to court and said that this business of extensions has been going on. On interference by this honorable court, this fresh tender process got initiated. Now, there is no dispute that we are the fourth highest. It quoted this time against the reserve price of 4 lakhs odd. It quoted an exorbitant rate of 11 lakhs and managed to become the highest bid. We are challenging it on 2 grounds. Firstly, that based on the Supreme Court judgment, it was already decided that this is not even in the area of operation. This respond number 6. And secondly, in the earlier process, it had quoted 4 lakhs and continued to ask for remissions, continued to ask for extensions. Now, merely because it quotes a predatory price of 11 lakhs, how can you simply, without applying your mind, how can you simply award this contract to these two? That is, in a nutshell, that is the.
It's a different issue. Okay, but
There are judgments of this honorable court which say that this predatory pricing needs to be curbed.
no,
because-
but then, if they're not defaulting,
They are defaulting. That is why they asked for extension and remission in the
no, that was earlier, in the
Earlier.
earlier round.
earlier round.
Now, on the
When
basis of this,
your lordship will kindly consider this aspect, my lord. When the quoted price was 4 lakhs, they could not pay, and till the eve of the tender process, they continued to ask for extension and saying that we are incurring losses. Now the same party comes and quotes a price of 11 lakh. Will the authorities shut their eyes to that aspect and award the contract?
at the end of the day, if they have already settled the fishery with them, and it's 2 years now, and if there's no default, then what role?
That is an aspect, my lord, we would not know because the government has to.
But then why should they go on a roving inquiry on that issue?
No, I am not on that.
Because
There
unless there is something wrong, that was in the new chapter that has opened up.
no, one aspect is that, but the other important aspect is the apex court. If I may quickly place that judgment, my lord, if your lordship will kindly come to page 33. The apex court's judgment itself specifically this is the judgment in original, page 33. The type copy, my lord, this is not very legible. We are given a type copy at page 31. Your lordship may straight away come to page 32. The second paragraph. This is the operative portion. In our view, this fact that there was no amalgamation between Pargat Society, which is us, with the newly formed society, namely Kora Society in 1978, does not ipso facto lead to the conclusion that the registration of Kora Society should be cancelled. The order of the Deputy Registrar dated 24/10/96, which was passed as a consequence of the order of the government dated so-and-so, appears to proceed on a misapprehension. In the circumstances, we are of the view that the Pargat Society and the Kora Society both must be deemed to be in existence. Now, this is important. Therefore, if the registration of both the societies are in force, the question would arise as to the respective areas of operation of those societies. This will depend upon an equitable distribution of the available area of operation between these two societies, and thereafter leases could be separately granted to each of these societies in regard to their separate areas of operation in accordance with law. We therefore modify the orders of the High Court as also of the government, and we also set aside the order dated so-and-so by which the registration of the Kora Society was cancelled. We direct the registrar of the cooperative societies or other competent authority under the Assam Cooperative Societies Act to issue notice to both the societies, namely the Pargat and Kora societies, and divide what should be the equitable area of operation of each of these two societies. This will be done on the basis that both societies are in existence. Once the area of operation is equitably distributed between the two societies, the government will proceed to consider the grant of leases separately in regard to each of the societies equitably to the extent of the area of operation of each of these societies. Well, the basic, what the apex court took note of is this is not like a normal contract. The fisheries rules itself conceives of
This is with regard to a different set of facts, I think.
The question
You
that,
see, it doesn't mean that when you are, just because you are in some area, that you will be the settlement holder for all times to
No.
come.
I'm not on that. Had it been only us, there are others in the area of operation. But the fact remains that this party, respondent number 6, was never in the area of operation. That is why it was given.
That is a question of fact which have to be decided. The Supreme Court has not decided that.
It was remanded back, and
Yeah.
accordingly, based on that, a decision was taken. So even in this case, if your lordship, assuming your lordship does not want to go into those areas of fact, if your lordship remands the matter back, and they have and issues a direction that they will consider the whole aspect in the context of the judgment of the Supreme Court and take a fresh decision on the matter. Because-
I don't know. But what about this,
and they-
in this serial number 6, the petitioner, who is he? He's. How is
Another
he?
tender, another tender. I don't know what their ground of challenge.
He is the highest bidder, but not valid bidder.
Not,
Not valid bidder. He is the highest bidder, also, but not valid. And the respondent number is the second highest valid bidder.
and your father?
Private
Private
respondent number 6, Lordship.
His bid value is the second highest, but he is the first valid bidder also.
Okay, so we have to dispose of this other writ petition also, that means. Okay, so let him be, well, it's a problem. In his absence, would it be proper to decide?
Ultimately, both the cases have to be decided together.
Correct. As no one appears on behalf of the petitioner in WPC 2744 of 2022. This is the matter. The matter is adjourned for 2 weeks. This is the matter. There's no stay order, no?
No,
No.
no. They are five minutes. Obligor.
Lordship, here the affidavit has been prepared and signed for waiting. Lordship may take it up next week.
Mr. B. Chowdhury, Learned Counsel for this.
BTC.
BTC submits them. Affidavit has been prepared and sent for vetting. He submits that the same will be filed within
Within 1 week. Sir.
a week, are you sure?
Yes,
Within a week, list the matter after the week.
Date maybe. It may be given.
Item 10,
Maybe 7 or
7 November.
This is a tender matter regarding the settlement of fishery. And in the last order, Lordship has provided them 15 days time to take a decision.
Who is appearing? Mr. Sharma. Where is he?
He was here.
Yes, here. What to do? You call him? We'll take it up after some time.
item 13,
May it please your. Lordship kindly note certain dates in this matter. This is about supply of dietary services to the patients of Nalbari Medical College.
Yes,
My lord, kindly note the date, my lord. First date is 7/12/2023. That is NIT was floated for supply of dietary service to the patients of Nalbari Medical College, which your lordship will find at page 36. Lordship can note down the date and page. Next date is, I'll just show next date that will convene on 28/12/2023 was the last date.
28/12,
12/2023.
last.
Last date of submission of beat. That was till 3 p.m. Your lordship will find at page 36 itself. Then on 28/12/2023 was opening of the tender. 28/12/2023 at 3:30 p.m. Which your lordship again will find at page 36.
Tender was opened on 28/12/2023. Your lordship will find at page 62. 28/12/2000. Page 62 is the comparative chart. Out of 9, 4 qualified. Out of 9, 4 qualified. Then thereafter, on 6/2/2024, financial bid was opened. 6/2/2024, which your lordship will find at page 63. Now, now they have written letter to us, that whether your amount which you have quoted, we were the lowest, whether that was inclusive of the GST, which we justified it, and we said that it is inclusive of GST. Your lordship will,
When did they send you a letter?
they have sent us a letter. Yes. At page 65, date. 65 is the reply. Date now. Dated 6/2/2024. At page
No,
65.
that is their letter or your letter?
My letter. My letter. At page 65. At page 65, dated 6/2/2024. Most sister like to undertake that the quoted price in the tender for cost of die so and so is inclusive of 5% GST. This is not disputed. That's not a disputed.
Yes.
So now this is now thereafter. Why we are aggrieved, my lord? Because they have decided to cancel it at page 66. That's the impugned dated 25/3/2024. At page 66 is the impugned. And the bid status cancelled. Your lordship will kindly look into it.
The impugned order. or
Impugned
letter.
order, 25/3/2024. There's an online which is downloaded. This is also not
Where
disputed.
do you get the date?
These are online, my lord. They have not disputed.
No, but where do you get the date?
It-
At page 66, where do you get the date? 25/3/24, that we said.
Uploaded by them on those dates, now uploaded.
So
They have
no date,
uploaded.
no date is there.
Yes. By the authorities, they have uploaded.
Okay. So they cancelled the NIT.
Yes, this is, we are agreed and before this on report. Now, my lord, there is an affidavit which has been filed. First, your lordship will kindly look into the NIT at page 36. 36 is the NIT.
Yes.
Please look into it, the organization name. Serially, bid date, bid end date, so and so. Organization name is Nalbari Medical College and Hospital. Organization name. At first is the bid end date time, bid opening, bid offer value, ministry date, department name, organization name.
Yes,
Nalbari Medical College and Hospital.
correct.
Now, lordship will kindly turn to page 41. 42. It was 500. At page 41, buyer added bid experience. So this is the
Buyer
added
added with specific.
specific ATC, additional terms and condition.
Yes,
So one, the bidder shall be dietary service provider having valid license. Bidder should have from the state of Assam, it was having experience similar nature, that was also having. Number two, on daily basis of minimum 500 bedded hospital.
yes, a bidder should have from the same, bidder should be,
Should have,
not we should have.
should, no, but here bidder should have complete to.
Is it bidder
page
so should
41.
be or should have? How can it be should have?
Should have actually.
How can it be should have?
Yeah, this
Should
is
have
not
what?
there. One. It is not my document, my.
I know. So, yeah, this bidder should have what? One samosa or what? Mr. Gogoi,
My lord, I think my lord, some portion is missing.
that is what.
Yes, it should, who you are. How I will do mission?
No, that's
All
what I'm saying,
responsibility I have. I can't add or I can't.
Should have to be from the state.
Should be from the state. I think it
Have
should
to
be
be from the state.
So these are the experience.
Otherwise, my lord, on the qualification part, there is no dispute.
But I am just showing it.
Okay.
Record.
There is no dispute.
So now the
now-
only thing
now-
is that he's challenging the
Cancellation.
cancellation.
Now, my lord will kindly see why I am showing it.
Let us see a comparative statement.
I will show it. Kindly see, comparative
You're
statement.
the lowest.
Yes,
Okay, so that is not,
Comparative
so that is not
statement.
disputed.
comparative statement, kindly look into it. Page 63. Page 63.
Yes.
Page 63. Kindly see number one, SIB Enterprise.
Yes.
SIB Enterprise. Total price is 1 crore 65 so and so. Rank is L1. This is for a period of 2 years. L1. Now please mark number two, Sri Ganesh Traders, who is L2. Why I am showing specific? 1 crore 29. You have, your lordship will mark this. Now, at page 64, per mil value is there, page 64. Kindly turn to page 64. Is estimated number of patients 64. Total price. If your lordship looks into consignees,
Estimated number of patients per
per
day, 200.
is 200. Cost of diet, feed so and so is 79.85 per meal. Total price is so and so. Lordship got it? Now, lordship has Z65 inclusive of GST, then the cancellation. Now, cancellation is at page 66. Now, why they have cancelled? Now they have given a reason for cancellation. Please look into the affidavit filed by the state.
I respond number 5.
Yes.
Which page?
It will be page 67. Kindly look into it. Page 69 of the affidavit. 69.
Yeah,
See paragraph 4.
yes.
That with regard to the statement made in 3 of the petition, deponent begged to submit that a bid cancellation was done in the interest of public service following an unanimous decision of the tender and procurement committee with the approval of the competent authority. Moreover, GM portal also provided the clear option to cancel the bidder.
Let us go to Annexure A straight away.
Connection
Annexure A, page 78.
78. This is a proceeding and final outcome of dietary services. So at page 78. Lordship got it?
Yes.
Now, Lordship will see last 2 paragraph. In compliance of GM direction, while proceeding with the tender process, it has been observed qualified L1 and L2 bidders after final evaluation as published in GM portal have quoted a very low rate of 79.85 inclusive of 5% GST by L1 bidder and rupees 88.50 inclusive of 18% GST by L2, which will never meet the patient per day expenditure as per the prescribed daily diet menu published along with the bid document in page number 13 and 14. Tender and procurement committee conducted a local market survey and also assessed the dietary service provider, existing supply rates in different medical colleges of Assam, and concluded that providing daily hospital diet as per the prescribed daily diet menu is practically not feasible at the quoted base rate of 70.85 by L1 bidder and 75 by L2 bidder. That's the reason.
So you're not the lowest.
Now, I am the lowest. They said the rate which you have quoted
It's too low.
that will not be, it will be not be proper to the the patients. Because we don't know what will be the quality of the food, so low rate. That's the reason they have quoted. Now, if your lordship looks into it, the now kindly see the clauses of the NIT. Page 37, then I will show the reply, page 57 of the writ petition. Then I will show my reply, 57 of the terms and conditions. Page 57.
Yes.
Page 57. This is the monitoring grade evaluation. C1, evaluation of offer for award of contract. What you got it? Number 1, Nalbari Medical College and Hospitals have considered awarding the contract to those bidders whose offers have been found technically, commercially, and financially acceptable. The lowest per day cost of providing food as per the attached BOQ will be considered as the lowest bidder. The institute reserves the right to counter offer price against price quoted by any bidder. So this is which they could have done it, but they have not done in the instant case. And I'll show it. They can ask for a counter offer. The lordship will kindly see institute reserve the right to counter offer price against price quoted by any bidder, which they decided not to make any counter offer to any of the bidder. Now, your lordship will kindly.
Just a minute. Check. Just per day cost.
Now, if you see 2, if multiple bidder quote same L1 price in a financial bid, then the selection of the L1 bidder will be based upon following points. This is not the case. Because if it is same, then the following. Now, if your lordship looks into monitoring of quality of service, 5, kindly see 5. In case hygienic, proper cooking methods and quality of raw materials are found to be lacking, and or any delay in service, the authority will impose penalty as per the attached penalty chart. So if I quote a rate which they found is excessively low, and if they found the quality is also not been good, they can cancel it. Now, what is my case, my lord? My case is, kindly see my reply. See, my lord, my reply.
Yes.
Page 100. Please look into 100. This is, which is nearly about 20 kilometers, maybe less than 20 kilometers, is in the same district, is a Borpeta Medical College. Page 100, kindly be looked into. Same department. This is, kindly see organization name. My lord, this is Fakhruddin Ali Ahmed Medical College and Hospital.
Yes.
At page 100. Lordship got it. Now, the contract period also 11 months, 5 days. Now, if your lordship turn to page 104, 104, estimate number of patient per day is 500. Now, at page 118, please look into 118, 118. Now, if you see at 118, 22, diet schedule is as under. If you see the diet schedule, exactly at same at page 47 and 48 of the writ petition. Same. Maybe here we find that it is some added dietary articles are there. But here, in my case, 47 and 48, kindly mark 47 and 48, that diet articles, diet chart. And if your lordship compares the diet chart with this 118 with mine at page 47, 48. See 47, 48, kindly compare. This is the diet of Nalbari Medical College compared with 118 diet chart of Borpeta. Some items will find in more. Morning tea is there, where your lordship will find tea and with breakfast. Compare with the diet chart. Is almost same. Now, if you see the work order at page 134, 134, 134.
Yeah.
Now, you see 134, service provider details at page 134. Now, this is the L1 person at page 134. See service provider details. See Ganesh Traders. What's it got it? Okay,
Yes.
Ganesh Trader. Now my lord will kindly see 135. 135.
Yes.
See on the top at 135. 73.5. So my lord, it is a distance of 20 kilometers. Same department, same tender floated in different places. Here you have found 73.5
Where 73.5?
on the top at 135. On the right hand side, 573. So per patient, 73.5. My per patient is 79. Now you say in your affidavit, saying it is no, this will be low quality or is we don't. Now why you have said, I could have very well understood. If this was not done, then I did have no case at all. Right to equality, you cannot now say that no, we are not considering your case. And this person, Ganesh Trader is L2, so far in my case. That's why I said, please mark my lord the who is L2. Same person. How can my lord, I have no case at all. How can you settle with a person with 73.5 and you justify my case that your case, the bid is so low. That's why we are decided to cancel it. That's why the evaluation committee decided to cancel it. 20 kilometers, both same. Nalbari Medical College Hospital and there is Borpeta Medical College Hospital. So that's my case, my lord. And specific case we have.
What is
made
the difference between these two hospitals? How many
It's
distance?
adjacent district. In Nalbari, then Borpeta. Fakhruddin Medical College and here is Nalbari Medical College. It was a civil hospital, then medical college. Now, not only that, I made a statement that they have to tell the court what the information from my client. Kindly see, I have made a statement at page 96. Kindly see my case. 96. Page 96 of reply of their affidavit in opposition. Kindly see my paragraph 10.
Yes.
That with regard at page 90, that with regard to the statement averment made in para 17 of the affidavit in opposition, deponent stoutly denies the averment made therein and puts the respondent to the strictest proof thereof. Deponent also reiterates and reforms the statement made in the preceding paragraph of the instant affidavit. Deponent further states, primary ground for cancellation of the instant tender is that it is not feasible to the deponent to provide a dietary service at a rate of 75.85, excluding GST. However, in a similarly situated hospital, such as Fakhruddin Ali Ahmed Medical College, Borpeta, Respondent Authority issued NIT dated 15/3/2024 for providing the same healthcare kitchen and dietary services wherein petitioner also participated and quoted a sum of ₹79 per diet feed and subsequently emerged as L2. The Respondent Authority has awarded the contract of the State Medical College Hospital in favor of Messrs. Ganesh Trader at the rate of 73.5 per diet feed. In spite of the fact, State bidder has quoted 73.5.
Yes.
Not only that, my lord, kindly see 97, the last paragraph.
Yes.
97. Moreover, 97, the last second paragraph. Moreover, as per knowledge of the petitioner, Respondent Authority has awarded similar contract providing healthcare kitchen and dietary services to Jorhat Medical College and Lakhimpur Medical College for the year 2024 in favor of L1, who have quoted less than or equal to rate of the petitioner. Thus, in view of the matter, when a similar situated case contract is awarded to a bidder so and so, petitioners should get equal treatments toward the, so this is our case.
One question is this, cancellation,
Yes.
that 78. This, cancellation by this committee, what is this committee called?
Yes.
Page 78. Now, this committee was the same in all the thing? Huh?
No.
Huh?
Different college, they have different, they select different.
Anyway, yes,
Whatever may be.
but then,
Issuing organization is the same.
huh?
Issuing organization is health department.
Well, here, well, first of all, let me clarify that part. So far as the present NIT is concerned, it has been issued by the principal, Nalbari Medical College. There is a separate committee, my lord, constituted by this college.
Maybe.
No, even then, well, let me complete it, my lord. The committee, after, my lord, opening the, my lord, technical bit, found this, my lord, 4 or 3 bidders to call it. Financial bid was open. Thereafter, my lord, these minutes that I placed in the affidavit, that lordship will see, they verified and they found that, my lord, it's too low.
How?
And reason is, my lord, the same petitioner. After this, my lord, civil college, the civil hospital, Nalbari Civil Hospital, which has been amalgamated with the medical college now. Petitioner was supplying the food articles in the civil hospital. So, my lord, because of the new inception of the college, we have to make a, my lord, interim management. So he was allowed to continue the food supply. And as on date, because of this, my lord, litigation and all, petitioner has been supplying at the rate of 120 rupees, my lord, per patient per day to this medical college hospital.
To which college, to which?
Nobody. He is continuing even during the pendency of the writ petition, even today. Lordship will see the bills. Same bidder. Now, when it comes to the bidding part, my lord, he has stated that inclusive of GST, it will be 79.88 or something. So that's the reason they say that it will not be viable. And my lord, I can show that.
But then you have not mentioned all this.
Well,
You have not mentioned all this.
But it was separate NIT was voted.
Lordship, may I read, my lord, the minus, my lord, page 78.
Yes.
Page 78. In compliance, my last second part, which has been read by the other side. In compliance of the JAM direction, while proceeding with the tender process, it has been observed that the qualified L1 and L2 bidders, after financial evaluation, as published in JAM portal, have quoted a very low rate of rupees 79.85 inclusive of 5% GST by L1 bidder and rupees 88.50 inclusive of 18% GST by L2 bidder, which will never meet the per patient per day expenditure as per the prescribed daily diet menu published along with the bid document in page 14 and 13 and 14. The Tender and Procurement Committee conducted a local market survey and also assessed the dietary service providers' existing supply rates in different medical colleges of Assam and concluded that providing daily hospital diet as per the prescribed daily diet menu is practically not feasible at the quoted base rates of rupees 75.85 by the L1 bidder and rupees 75 by the L2 bidder. That is, madam, excluding GST, madam. Now, in the next page, because this was not placed by the petitioner. Considering the nutritional requirement of the indoor patients as well as the hospital authority, responsibility to mandatorily provide nutritious diet for proper recovery as per the prescribed diet menu, total tender bill was estimated and minimum per patient per day rate of rupees 120. The total tender value clearly reflects the approximate daily rate per patient. However, it has been observed that such quoted low rate, which is about half of the approximate estimated rate, will compromise the food quality and the patient will be deprived of the prescribed diet. In the interest of patient care, the tender committee so and so, ultimately it was cancelled. And in the affidavit, you have stated that, madam, presently the present petitioner is supplying at the rupees 120, which you cannot deny.
Third page.
Yes, sir. Page, my lord, 73, para 13. Lordship will see page 73 of the affidavit. Running page number is 73. Para 13. With regard to the statement made in para 14 of the writ petition, the deponent makes a statement.
With regard to same arrangements with
Paragraph 12 of the petitioner, the petitioner is supplying dietary service to Nalbari Medical College and Hospital since amalgamation with SKM Civil Hospital at the rate of 141.60. As on date, he is supplying at this rate. Per patient per day as per the district hospital diet menu. However, it is apparent that the petitioner is intending to provide the same dietary service at a much lower rate of rupees so and so, which clearly reflects the intent of the petition compromise with the food quality. This is the reason, man. One of the reasons we can say, man. And in my lord, I can place one judgment, my lord, that is Silpi construction. The Honorable Supreme Court has held that, my lord. It's not required that every ground should be mentioned in the minutes. In the affidavit, we can supplement it. I will place the judgment, my lord. Very categorically, Honorable Supreme Court has said. On my, in regards to tender. It can be supplemented. And my lord, this is otherwise apparently, my lord. He has not denied in the affidavit. That no, I am not supplying at 141. Just because the petitioner is the L1 bidder.
Come to page 94. Right.
Yes, sir.
This is at page 32. This is also in the writ petition. I have written the letter which they have written to us, which is justified here at page 32 kindly writ petition. Page 32 of my writ petition. This is their government approved rate. And they are not justifying. What about Borpeta? He's keeping quiet.
No, Borpeta, my lord,
Why?
that's why I have made the statement.
Why?
Borpeta,
Just a minute,
my
just a
lord,
See,
tendering
page
authority is
32.
different,
Just
my
a
lord.
minute.
Yes.
Let me
Page
ask the
32.
question.
Kindly see. Page 32. They have asked me, my lord, kindly see. Directed to provide children at government approved rate. It's their rate they is given, you provide that rate. That's why we have given that rate.
No, if that-
And when the question of tender comes, my lord, it is my prerogative. They have written that.
Let me ask.
Yes. Right.
So far as this part is concerned, my lord, this part, so why it was what minus of the meeting, my lord, that I can place, my lord, if required.
But
Lord,
no, whatever
page
has
32,
been done,
my lord.
the fact remains that 141.
It was the rate, my lord, at which the petitioner was supplying at that point of time in the my lord,
Correct.
civil hospital.
Is supplying.
Yes.
So,
So in order to-
so he's making a big profit. So just because he was making a big profit, now because competition is there, now he has to cut down on his profit and he's doing it for
My
less.
lord, at that time also probably, my lord, he has got that particular work, my lord, by of a tender. It's not that, my lord, it was
Correct,
doing-
correct, but you see, but then how can you blame him
No,
for
I'm
trying
not
to earn
blaming,
a
my
big?
lord, but
How
the
can you, no,
tender-
no, please understand, how can you blame him for trying to, for having made a bigger profit in his
No,
earlier years?
my lord, nowhere we have stated that, my lord, regarding profit.
No, no, but you can just imagine.
Well.
When you have told him to supply at 141 as per government rate, he's been supplying, what is wrong?
No, my lord,
It is
so
not
far as, my
that-
lord, pursuant to a, my lord, lordship will see, as so and so is amalgamated with so and so, and as per decision taken in the meeting minus
Yeah.
that is so and so, you are direct to provide. So
Correct.
probably he was there in the meeting, it was taken into consideration that since, my lord, it will take time to, my lord, to go for a fresh tender, and my lord,
Maybe,
my lord, we
whatever.
cannot, my lord, moment it is amalgamated, patients are there.
He might be there in the meeting, so what? He will always try to take the maximum. Government also will try to save the maximum. There's no harm.
No, here, my
Yeah.
lord, the tender committee's decision, if this honorable court wanted to step into the shoes of the, my lord, tender committee, my lord, I have nothing to say. They had experts, they decide that so far as this hospital is concerned, the rate 79 or 78, whatever is quoted by the petitioner, is not feasible.
We will
Yeah.
have to see that.
My lord,
We will have to see. You see, when all
their
the,
lordship is,
when, you
entering into
see,
the decision itself, not the process, my lord.
no. The decision.
Yeah.
The process also we'll have to see. What about Jorhat Medical College and Lakhipur Medical College? How much has it been settled?
My lord, it's not the same authority. That's why I'm saying, my lord.
No,
It's
may not
their
be the-
committee is different.
may
their
not be
rates
the
are
same,
different,
may
They have
not-
taken a decision, my lord.
May not be the same.
Yes. Then
It-
lordship will give a direction that, my lord, in every medical college, there will have to be one tender and
No,
the
no,
people have to.
no.
How it's possible? my
No,
lord? The
no.
committee has decided.
You see, there is a thing. It is not that Lakshmipur or Jorhat or someone has got a very high rate of prices compared to other districts. If you can say that Nalbari and Barpeta, the prices of foodstuff are huge, then I can understand. But where is your decision making process based on what? Just saying that we have done a market survey. Market survey of what?
No, my lord, that's
You've got to
120 rupees, that is according to them.
You've
Here,
got
my
to-
lord, is
yeah,
too low,
yeah, yeah,
almost
no.
half of the. my lord,
Too low means what? Market survey of what have you done? Have you done market survey of bread? Have you done market survey of onions or market survey of cement bags or what?
But that by record I can place, my lord. That, my lord, statement recorded in the minutes, my lord, on what basis they have recorded it, then I can place, my lord, that some record will be there, my lord. Even in, my lord, in Assam Medical College, in a similar issue, I found that, my lord, it is the food inspector who of the district who provided that it should be minimum should be 120. In other
Maybe,
case, I'm
maybe.
just saying, my
Ah.
lord. So probably there have to be something, my lord, of Nalbari district too, my lord, to come up to that decision that yes, 120 rate is the feasible rate.
Maybe.
1 or 220, 10 or 20
We'll,
will be
we'll,
up and down,
we'll,
depending.
we'll give you time to produce that. It's
Yes,
okay.
my lord.
But then there's a stay
Including-
order, correct, right now? Stay order is there.
There is even no.
Huh?
There is no stay order.
But we have not proceeded. madam.
They have
Because
not
ultimately
proceeded.
third party
They have
right
not
will come in
proceeded.
and again.
That's why.
chaos.
Because it appears that petitioners have a case. Prima facie, there appears to have some sort of a case.
If there is a base price of 120 is a base price, then the situation, I mean, there is no base price.
No,
they have
no,
mentioned.
no. There are one thing. One is with regard to Jorhat Medical College and Lakshmipur Medical
My
College.
lord.
What is the prices there? Given. I just want to know that. And then I want to know, of course,
There are now, as on date, 13 medical colleges.
maybe we are only asking for 2 or 3.
No.
If you want, you can bring all. If you bring all the better.
Yes, yes.
All the better. You can bring
And
all.
the tendering authority, madam, who has
Huh?
published the tender.
No. At what rate are they supplying the food stuff?
Right.
That's all. That's all I want to know. That's all. That's all. I don't want to go beyond that. I just want to know whether which district has the highest prices of vegetables. And all. I just wanted to know that. And
I will
then,
come up.
because if your government rate for the same college was 140, which he is supplying now, and now
But not
because
college,
and he
just
has
civil
come down
hospital.
now to 79, what is wrong? I don't understand. Why did you allow it 140 in the first place? If your decision now is that 79 is too low, then
My lord, the reason is at 141 rupees, my lord, the petitioner is presently supplying the, my lord, entire same, my lord, diet schedule. Same diet schedule, my lord. So, my lord, if the same party says that no, tomorrow I will be supplying it, my lord, every year it goes up, my lord. It escalates, my lord. Here it is seen, my lord, for last 3-4 years it is continuing at the rate. Suddenly, now he says that I will give at 79. Though for last 5 years, my lord, when the rate, of course, my lord, there is escalation. My lord.
no, this letter has been issued in 23, not 24, not last 5 years.
No, no,
It was
no,
last
no.
year.
He was, I will, that minus, I will place it, my lord. He was continuing, I will place the bills also. Say of 22 or 21.
Bills
or
are not
20.
necessary.
No, to show the rate, my lord. That the same rate was continuing. That's what I want to point out. By placing the bills, my lord. His own bills that he has
Anyway,
made.
you see, I
I
want.
will try to, my lord.
Yes,
Yes. I will try to satisfy you, my lord.
Right. Heard Mr. D. Das, Leonard Senior Counsel for the petition, as well as Mr. B. Roy, Leonard Counsel for the Health Department. The petition has put to challenge the impugned order cancelling the NIT dated
7/12/2023 and I.
7/3/2023.
7/12/2023.
7/12/2023. By which tenders had been called for providing health care kitchen and dietary services to Nalbari Medical College and Hospital, Nalbari. Next paragraph. The petitioner's case is that subsequent to the selection process carried out pursuant to the NIT dated 7th of 2023. The petitioner was selected as the L1 bidder, having quoted the rate of rupees. Where is that?
Page 65 of the comparative statement, 1 second.
The rate of rupees
64,
rupees
64. Rate is
rupees 79.85
inclusive of GST.
inclusive of 5% GST
Yes.
for one patient. Shri Ganesh Traders
L2.
was L2 at the rate of rupees
Ganesh Trader at page 63. They have given 1 crore 29 lakh. 1 crore 29.
No, I don't want that.
Wait. Kima ase 30 only. That is the Kima ase 80 Kima. One second, is there in the
My
input
lord, it is
order.
my lord 88.50
88.50
at 18% GST.
with 18% GST.
Yes. Minus, it is in the minus.
The petitioner's counsel submits. Yes, Farah, that the NIT was cancelled on the basis of 78. On the basis of the unanimous decision taken by the Tender and Procurement Committee in its meeting held on 7/12/2023. Wherein it was held as follows, page 78, the last two paragraphs. Wait, last two and then page 79. Let's say page 78, 79, huh? 78, that's what. Next. The petitioner's case is that in respect of the NIT dated 15/3/2024 issued for supply of healthcare kitchen and dietary service in relation to Fakhruddin Ali Ahmed Medical College and Hospital, Barpeta. Shri Ganesh Huh?
Ganesh
Traders
Traders.
was selected as the successful tenderer at his rate of rupees. How much?
73.5.
73.5. Yes. Per patient, per day. He also submits that the petitioner is, has, also, so here submits that the respondents have selected the successful tenderers for other medical colleges in other districts of Assam, especially Jorhat Medical College and Lakhimpur Medical College, at more or less more or less similar rates as quoted by the petitioner. He accordingly submits that there is no justification for cancelling the NIT when the petitioner, when the items to be supplied in all the medical colleges are more or less the same. That's your case?
And only on a counter offer, there is a provision, which they could have offered. If that was so low, why they have not given a counter offer as per terms and condition of the NIT?
Page?
Your lordship will find, that is page 57 of my writ petition.
The Learned Senior Counsel also submits that if the state respondents were of the view that the petitioner's rates were too low, the respondents would have applied the
Page 57.
provisions of
Yeah.
the evaluation of offer for award of contract by making a counter offer of the price quoted by the petitioner. However, the same was not done. Next paragraph. Mr. B. Gogoi, the Learned Counsel for the Health Department, on the other hand, submit that this court should not substitute its views with the views taken by the Tender and Procurement Committee with regard to the rates offered by bidders.
As well as, my lord, the Borpeta Medical College, they have a separate committee, my lord. It was considered by a separate.
In as much as the Tender and Procurement Committee of Barpeta College, Barpeta, whatever, what the medical health college, is composed of different persons, is constituted by different persons vis-a-vis the Tender Procurement Committee of Fakhruddin Ali Medical College and Hospital. Similarly, Jorhat Medical College and Lakhimpur Medical College would also be having different tender and procurement committee. And the decision made by one committee of a particular college in respect of the same kitchen, what kitchen something?
Yes, sir.
In respect of the supply of dietary articles cannot be
Healthcare kitchen and dietary.
equally applied to other institutions. Next part. Mr. B. Gogoi further submits that the petitioner has been supplying dietary articles to the Nalbari, no, to the Nalbari Medical College and Hospital, Nalbari, for the last 5 years at the rate of rupees 141.60
141.60
per patient.
per
As such,
patient per day.
per patient per day.
As
As
per
such,
district hospital guideline.
there was a reasonable apprehension on the part of the committee, tender and procurement committee, at the rate quoted by the petitioner for supply of dietary articles after the tender and procurement committee had conducted a local market survey and had assessed the dietary service provider existing supply rates in different medical colleges of Assam. So they have also considered other supply rates in other colleges over there.
I will place it.
Next. Mr. B. Roy submits that the matter may be adjourned so as to enable him to produce the reasons for the tender procurement committee to come to a decision that the petitioner's rate of
79.5.
85
Yes.
was too low. 75.85 was too low for supply of dietary articles.
79.
He also submits that he will also produce the rates of dietary articles supplied to patients per day in other hospitals in other districts of Assam. List the matter on.
But after two. Lordship will give it part of
My partner is
And one more thing, a slight,
Minor
minor correction, my lord. The petitioner has been supplying for the last few years, my lord. I can.
Okay, don't say 5 years, say few years.
I didn't say, because I want to verify with my client, because it is 2022 when this Nalbari Medical College was established.
The prior to
It
that
was
he
a
supplying.
civil
I
hospital.
have the knowledge.
That's why I didn't say. I said whatever he
is
said,
continuing.
Anyway,
I wanted to, yes.
no,
Prior to 22.
Why not one thing, when there he is saying that it is a different committee, ultimately it goes to the hand of the government. It is the same organ department.
We
Why
cannot
the
fix a
government?
rate.
No, Mr. Counsel, you please read page 78, the last paragraph carefully.
Yes.
The tender procurement committee has not only done a market survey, but rejected your rate after considering the rates in other medical colleges. So that is in your favor. That's what I'm saying. You did not lay stress on that point.
Yes.
You see, so what he's saying, that rates of Barpita and Nalbari will be different from others, may not be correct, because the procurement committee in page 78, last para, has taken into consideration the rates being provided in other medical colleges.
Other medical colleges, that's in medical, Guwahati Medical College also, the rate which was provided, my lord, that was different, my lord, rate, maybe.
My lord,
So anyway,
I agree, my lord, in other medical colleges,
Yes.
there are lots of complaints, my lord. That's why I will place everything now.
But nowhere have you stated that the quality of food is bad.
Yes, that's.
Nowhere.
No, not quality of food, my lord. We have considered his rate, my lord. 141 is continuing, my lord. We have not blacklisted him.
You
or
have
have
given
issued
that
any
rate.
penalty.
You
No,
have.
141 is good, my lord. Now
Who has given?
79
You have
is
provided.
some-
You have provided.
No,
They
no,
want
I am
more
not
money.
saying that.
Huh?
Regarding the new rate.
But what about the other places? Barpita, why are
Yes,
you
what-
giving
what-
it
what-
Well,
79?
There was 2, 3 round of litigation. Finally, it could be settled and going for another round, cancelling again, my lord. Twice we were cancelling, to my knowledge, my lord. I can place the judgment.
No, why?
His honorable court finally upheld our decision of cancellation, then pressed NIT again. Again, the same petitioner, Ganesh Traders, he, my lord, preferred to read petition.
Or is it because Ganesh Traders was not the lowest that this has come about?
Yes.
No, that cannot be because
Cannot.
there we have rejected. He
There-
approached the honorable court. These petitions were dismissed on our being contesting.
Because
the-
he's quoting nearly the same rate.
No,
In
that's
fact,
why we have said.
in fact, his rate is lower.
Yes.
His rate is
Even-
lower
even-
because he's
that's
giving
why, my lord, we have-
18%.
No,
18% GST is
Lordship will
included.
kindly consider there was 4, my lord, technically viable bidders. my lord.
60.
We have mentioned only 2 because, my lord, others two were higher, near about 100. But, my lord, we cannot go for the 4th highest bidder. So we have cancelled it. my
Okay, list the matter after 2 weeks.
Time being adopted.
I'll list the matter after 2 weeks as part of.
Actually, already processed, the officer.
Item
10.
10.
Tender matter, your lordship.
Ah, yes.
No, we are supposed to, he may get it, I won't divulge the result, lordship. The officer is on leave, lordship. The concern, main officer is.
This has been issued yesterday. This letter.
Yes. I asked him.
Enough time has been granted to them, your lordship, and 15 days time and also 22 days now. It was listed last on 30/09. And they're playing with the time, your lordship, because the season time is going to be over. And if they get the bill after that, they have to pay the revenue out of nothing.
They don't want the revenue.
He's only cast.
Huh?
Nobody is in possession, lordship.
But someone must be doing daily fishing or something.
No, nothing.
Yes, lordship,
Nothing.
it is being carried out and articles are also being in there in the newspaper.
No, lordship, we are,
I have
But,
copies also with me. Your lordship.
15 days time.
Hmm.
2 months.
15 days time, already, the holiday was there, lordship. The officer has gone.
Lordship granted 4 days, then they asked for 10 days time and 15 days time was.
Lordship
granted.
then, 15 days, lordship, actually, he's on leave, lordship.
Who's on leave?
Relationship secretary is on leave. I think some function is also there.
Additional secretary to the government of Assam.
He has issued it. We are the senior most secretary.
Then we'll give them time, 10 days time. Let
Lordship
them
will give,
decide. 8 days.
3 or 4 days, your lordship, they decided on the Friday, your lordship. Because 10 days.
Mr.
again,
Council,
lordship,
this is not like selling
They are
chana or
getting
something
22
like that.
days time, your
You
lordship.
see,
then
this is
again 10 days.
government takes time. You see, they've got this, they've got to go from one desk to another desk, to another desk, to another desk. What to do? That's the way it functions. We have to be practical.
Lordship, they fix a date within this month, your lordship. Today is 22. Humble prayer, your lordship, because they have been taking time,
It
it's
is not
long time.
practically not possible, lordship.
But if you don't, next time your officer will have to appear.
Lordship, I'm telling lordship, he's on leave, lordship.
No, but yeah, we'll give you time, but the officer will have to appear if he doesn't come. He'll have to come here. And he'll have to make the selection here in the court with the file.
Selection has been made, only for the approval it has been given.
Okay, on your approval.
Selection has been made.
So he's approved.
Maybe.
Maybe.
Actually,
may.
actually,
I don't want to divulge the name. Lord.
He'll be knowing everything. In fact, he'll be knowing everything. Only thing that I don't know anything.
Anything, yes,
You both know everything.
yes.
No, Lordship.
He may have that actually.
Huh?
It has not been known to us.
Actually, he is the only person whom to give. He has lordship there. Later it is.
I know you're
secretly
the only
after what is
person
that-
left. You're the only person left.
But he is the only person. So for approval lordship, it has to go to the.
First and second are gone. So, so you're the third.
For approval, not only we have to give to. the
Okay, right.
minister.
Mr. P. Sharma, Learned Counsel for the Fishery Department, has submitted a letter dated 21/10/2024, issued by the Additional Secretary to the Government of Assam from a Fishery Department, requesting for 15 days time to complete all the required family formalities regarding settlement of number 14/15 Nishari Haria Fishery in Nagaon district. The in view of the prayer for time, comma, it is expected that the formalities should be completed on or before
Lordship may fix it.
4th November. Leaves the matter on 5th November. 31 to 3 is a holiday anyway.
Okay. 3 2. Lordship, he's on leave on till third Lordship. Fourth.
No, we have fixed
7 on 7 Lordship.
5th.
7 Lordship.
I think,
Because he will be coming on, I think either he will be coming on 4th or 5th.
you said he's on holiday till 3rd, so why should he come on 4th or 5th?
Here it is, as per my information, here the no instruction is festive, that he is on leave, Lordship. Some function. is there.
It is said that during the ensuing festive season, the key officials were on leave.
Yes, okay, it is written here.
5th, this is the matter on 5th.
Offline. Lordship.
All Lordship.
Look, in this case, we are appearing on behalf of the Silchar Municipal Board. We have got some instruction, but not fully. But my lord, what happened in this case? My lord, this matter still can be settled. I had a talk with my learned friend. Now, what happened, my lord? In the municipal market, there are certain materials were stolen. And the contractor who was doing the internal security of that area, in terms of the, my lord, the contract between the municipal authority and the contractor, that if any material is stolen, then they will be responsible. So, my lord, the stand of the municipality that you come and settle the matter, whatever you are to pay, we shall adjust with your due, whatever you are to get. So that is the position I told him, you go to them and they will settle the matter.
I don't know, yes.
No, regarding the stolen and damaged part, that responsibility is not there, but otherwise, an effort can be made.
Then you will go. But where is the affidavit?
Well, the affidavit, that instruction, my lord, I can tell your lordship. Your lordship can see this.
Because you see, this court has also
This is the only issue which is required to be settled, my lord.
you see, this court has directed you to file an affidavit.
My lord, exactly, my lord, but
And since August. Not only that, this writ petition is of 2016.
right. So there is a role, my lord, I admit,
Wha-
there is no,
Why should we impose cost upon the municipal board?
my lord, instead of going to all that, my lord, the matter can be settled. My lord, I had a talk even this morning with the executive officer. He said, if they come, then we can settle the matter. They're not coming at all. And your lordship can see the
But
matter.
supposing they go and then they don't settle, then again they delay.
My lord, in that case, what will happen, my lord, the practical field I am coming to your lordship. Now, supposing they don't come to negotiating table, and what will happen, then there will be disputed question of fact. Because here is the thing.
Maybe,
Well,
but
the-
we'll impose heavy costs first.
My lord, your
Then we
lordship,
will
can
send it to the civil court
can we see for a moment at page 16?
of the writ petition.
Yes, this is the agreement. clause 15, your lordship, when you see for a while.
Yes.
It is agreed that last, my lord, column 15, it is agreed that in case any theft or damage caused to the mall due to the negligence, incompetence or lack of attentiveness on the part of the security personnel, security service, the second party may be asked to compensation, provided that now in view of this provision, my lord, they are legally liable for whatever the materials are stolen, they are legally liable to compensate that. Now, these, whatever they are saying that has been stored by the municipal authority is because of this, my lord. If they come, my lord, instead, let the case be here. If they come, my lord, we can see that. whether it
Yes,
can be
what to do? You go. What?
I think who will approach their matter? Thing is that it is not clear the work, well, there are some disputed question put with their matter. But here I have completed the work in pursuance of the Honorable High Court's order, man. Because I have been terminated by the 2 months back. Then I approached the Honorable Gaudiaga. Honorable Gaudiaga directed me to complete. Accordingly, I completed the work.
Where does he ask you to complete?
Yes, my lord, that is your lordship will find page 29 annexure 1, my lord. I, relevant portion, page 30.
What has happened to this writ petition 5058?
That was
That is disposed of.
disposed. Because once I completed this period, my lord,
Where is the disposal of the writ petition order?
that I have not annexed. There is one line, my lord, it was withdrawn, my lord.
It was withdrawn by you.
Yes. Because it was, it became infractus, my lord, after completion of the period.
Their term was extended, my lord,
Yes, term.
till the, my lord, the 38/2014.
Okay, right. So you will go to them when?
My lord, I'll go in.
We will fix a date.
Yes.
My lord, in the meantime, my lord, if the municipality want to file, they can file. But if they can
No,
approach,
they have to file.
if they, yes, my lord, and if they approach, my lord, we shall see that the matter can be settled.
You have to file. There's a direction by
Yes,
the
yes.
court. Right, heard, Mr.
My name is H. Undima.
A. Chowdhury, learned counsel for the petition. Also heard Mr. S. Datta, learned senior counsel appearing for the
Yes,
Silchar
Honorable Court.
Municipal Board. Assisted by Mr. S. Datta.
Yes.
And their brother is also another S. Datta, correct?
Yes.
Right. The petitioner is the director of MSHRD Commercial and Industrial Security Private Force Private Limited. Let's take this order dated 17/5/2016. Let's take the first para. Let's have para 2 also, huh? Okay, para 1 and para 2. Then you write. This court. No, not this, but right. Mr. S. Datta, the learned senior counsel for the Silchar Municipal Board, submits that. This court has directed the Silchar Municipal Board to file an affidavit or to furnish instructions in terms of the order dated 28/8/2024. He submits that as per instructions received by him from
From the executive officer,
the executive officer,
municipal board.
Silchar Municipal Board. An offer has been made to the petitioner to appear before the said officer so that an out of court settlement can be reached between the parties. Mr. A. Chowdhury, learned counsel for the petitioner, submits that he has got no objection to meeting up with the concerned officer to have an out of court settlement. Next paragraph. In view of the consent of the parties, the petitioner is directed to approach the executive officer, Silchar Municipal Board on which date?
10 days, my.
Okay, within 10 days from today.
Yes.
A comma wherein an attempt shall be made by both the parties to resolve the grievance of the petition. Next paragraph. It is also noticed that the petitioner had approached this court earlier by way of WPC 5058 of 2015. And the petitioner had been allowed to discharge his functions and duties in terms of the agreement dated 30/08/2014, executed by the petitioner and the president cum chairman, Silchar Municipal. The above being said, the Silchar Municipal Board has not submitted any affidavit till date, has submitted any affidavit even after 8 years from the date of filing of the present petition. Accordingly, no, that's fair. The list is matter again on when? Which one?
After 2 weeks.
2 weeks, they
Okay, 11. This is the matter on 11/11. By which date the Silchar Municipal Board should file their affidavit.
Of license. Can I take back the pen?
Yeah.
Of license.
Time being item 24.
Wait, with the last. My lord, earlier, my lord, the practice which was adopted by the NF Railway was the supply of bedroll and maintenance of the AC coaches was a composite contract. Now, my lord, what they have done, they have bifurcated the contract into supply of bedroll is one part and other is basically, my lord, though the technical terms are, my lord, quite longish, but effectively, my lord, the work is escorting of the AC coaches. And my lord, to regulate the speed and all, this is the basically job. Now, at page 80 is the list of the trains in respect of which the work is to be done. An estimated value of the contract is about 21 crore. And as per the tender requirement, one who has got, I mean, my lord, 7.5 crore experience, then he is eligible. So on that count, there is no dispute. Dispute is only on account of one aspect, my lord. Please come to page 32. In fact, 31.
Yes.
9 was the bottom, my lord. Minimum eligibility criteria. The bidder should have satisfactorily completed in the last 3 previous financial year and the current financial year up to date of opening of the tender, one similar single service contract for a minimum of 35% of the advertised value. So to this extent, there is no difficulty. Fulfill. Completed this service contract includes ongoing service contract subject to payment of bills, etc. Then please come to next page. Now this is the bone of contention. Similar service contract means escorting contract for roof mounted AC package unit of LHB variant AC coaches by approved vendors included in the list of approved vendors issued by RDSO is, my lord, Research, Design and Standard Organization for manufacture and supply of electrical items. Now, this is the, my lord, part with which we are agreed. In view of this, my lord, we are ineligible.
So this
But
escort,
presently, my lord, this contract I am performing.
no, so
presently-
what, no, what is this escorting of AC coaches?
Yes, it's
So what do
nothing,
you
my
do?
lord. AC coaches, my lord, we are to depute our man who will regulate the ACs and all, that's all. There are several trains, my lord, for a period of 4 years.
Only ACs?
Yes, yes, only. No, my lord, that's why I said escorting contract for roof mounted AC package unit for LHB variant AC coaches. In fact, they're using the coaches twice. So basically in AC coach, we will provide men who will, my lord, regulate the AC and they will escort. Wherever the train goes, they will also go. That is the job. Now, this included in the list of approved vendors issued by RDSO from manufacture and supply of electrical items. That means the eligible bidder would be one who is a manufacturer and supplier of electrical items. At the end of the day, my lord, it is a service contract. This is not a contract for supply of, my lord, AC or other equipments. It is essentially a contract for providing service. Now, my lord, having regard to this, now there is an observation of the railway board, which NF Railway has not followed. That is our case, madam. If your lordship will kindly come to page 132. My lord, the original copy is at page 133, but it's not legible at some places, so we have provided a typed copy. During the recent CMG meeting held on 11th and 12th January 1990.
CMG means?
CMG to be useful. I think it is some body of the railway board, my lord.
But still,
Sure. We're getting it, my lord. I think it's something to do with comprehensive maintenance something. During the recent CMG meeting held on 11th and 12th January 1919 at Bangalore, CRSE, that's a senior officer, my lord.
what is CRSE?
That is also an officer, my lord. Raised problem of overpricing regime of OEMs in maintenance contract of RMP.
What is OEMs?
Original equipment manufacturer. That is what, when this manufacturer or the supplier are made to, my lord, perform the job, then they quote higher price. Then railway board feels that this is excessive.
No, but these OEMs.
OEM is the original equipment manufacturer.
So so only those persons who are working for those manufacturers can work in the thing.
No, it is the manufacturer and supplier who alone can do according to the tender. Whereas the job is a service contract.
No, only the manufacturer and the
Can be a bidder.
Ah.
He must be an approved vendor of that particular organization.
So supposing you have a fridge, say a Samsung fridge or something. If it goes wrong, you'd want to go to the Samsung and Workman only.
Yes, that is the case.
Then?
We have got electrical licenses. Absolutely, their lordship is not on the point. We did not go to the manufacturer of the Samsung in wherever the factory is located. Now, the tender condition indicates it is the original equipment manufacturer who will be alone be eligible. Railway board says, no, this is wrong. Because when OEMs are engaged, then higher prices are charged. Crisis management group, Miller. Crisis management group. I'll see here a see. CRSE.
No, there are OEM, then there is RMPUs.
RMPU, I know, Miller.
Ah.
Roof mounted AC package unit. That's the bogie, Miller.
the railway bogie. Nowadays, my lord, it's a new type. my lord.
Roof mounted,
Roof mounted AC package unit.
AC package unit.
Yes.
IOH,
IOH is, my lord, intermediate overhaul.
intermediate.
Yes.
O means what?
POH is periodical overhaul. Can I continue, Miller? Yes. During the recent CMC meeting held on 11th and 12th January 19 at Bangalore, CRSC, we are getting it, my lord, raised problem of overpricing regime of OEMs in maintenance.
OEM
contract-
is again, OEM.
Original equipment manufacturer. OEM in maintenance contract of RMPUs, it should be, my lord, it has emerged that the cost charged for IOH and POH scheduled by source other than OEM are substantially low in comparison to the cost charged by OEM. So Railway Board's observation is when you engage these OEMs to perform the job, then they charge a higher price. Therefore, Railway Board has already authorized PCME, that is Principal Chief Engineer Mechanical. Principal Chief Engineer Chief Mechanical Engineer. The Railway Board has already authorized PCMEs in this regard to follow their own criteria, while later mentioned under reference. In view of the huge cost difference, it is suggested that Railway may take a view on eligibility criteria by considering all factors, including obtaining the performance report. The railway so and so, where maintenance contract is placed on other than OEM. There should be a word, Miller, other than OEM. So Railway Board.
No, there's no other than.
Yeah, my lord, it is there, my lord. If your lordship would kindly come to page 133.
Yeah, there's no.
Beyond that, there is a word, my lord. Other than.
No.
Supposing, my lord, supposing in view of the huge cost difference, it is suggested that Railway may take a view on the eligibility criteria by considering all factors, including obtaining performance report from the railways, that is ECR, SWR, NER, WCL, where maintenance contract is placed on their own.
Is it other than?
Okay.
Is it other than? Page 133.
It is, my lord. We have checked that. Lordship, which?
The last line, page
Other than, the last
in
line.
133.
Lordship, I have the same copy, Lordship. Otherwise, my lord, there is no meaning can be called out. That is what, because the sentence is used earlier also. Lord. If your lordship would kindly come to. Yes, if your lordship would kindly come to the first para, fourth line. Scheduled by source other than OEM are substantially low in comparison to the cost charged by OEMs.
So now?
Now, based on this, my lord, other railways have come up with tender conditions which are consistent with the Railway Board prescription. The 134, my lord. After that subpara, hence it is proposed. Page 134, it is by Southern Railway, my lord. Tenderer should be approved source for conventional SG, SC or LHB type RMPUs
by RDSO Lucknow as per RSDO latest list of approved source on the date of opening. This has been maintained, but or tenderers should satisfy the following eligibility criteria. The bidder should have satisfactorily completed in the last 3 previous financial year and the current financial year up to the date of opening of the tender, one similar single service contract for a minimum of 5% of the advertised value of the bid. So they have modified it. Now, in fact, my lord, the contract which I am presently performing, that your lordship will see, and the scope of the work is same. For example, if your lordship would kindly come to page number 107, my lord, which is the present contract which I am doing, is coming to an almost end.
Okay, that is for Southern Railways. What about North Railways or Western Railways?
They have, my lord, position. Anyway, Southern Railway has done that.
Southern Railway has done, Western Railway has not done.
No, my lord, I do not know about other railways, but Northeastern Railway has not, NFR has not done.
What about Eastern Railways?
My lord, what I am praying for is, my lord, I should be allowed to participate. Tomorrow is the last day. I should be only allowed to participate, my lord. Other things I will satisfy your lordship. Tomorrow is the last day. No, subject to the outcome, my tender may be considered, but it will not be until further orders of your lordship.
No, but you see, now the thing is that, what is the arbitrariness? That's what I want to know.
Arbitrariness is, my lord, this is against the railway board's decision itself.
No,
Railway
no,
board itself has said,
no, it does not say, Railway Board has not said that
Yes.
you have to do away with this. It says that you can consider doing away with it. It has given discretion.
no, yes,
Discretion, exactly.
not true, my lord, true. But then, my lord, when railway board issues a circular, kindly see the language. Last para at page 132. In view of huge cost difference, it is suggested that railway may take a view on eligibility criteria by considering all factors, including obtaining performance report from the railways, etc., where maintenance contract is placed on other than OEM. Presently, my lord, kindly see the scope of the work. That's why I'm saying, as for the present tender, my lord, the scope of the work is at page number 79, my lord. Amongst others, if your lordship will kindly come to 79.
Another thing,
Yes,
this letter at page 132,
yes,
okay, this is of 2019.
yes.
And now it's 24.
And the tender which I have shown just now.
That
my
is
lord,
of 21.
Yes.
Now, what has happened in all these from 19 to 24? What about the Western Railway, Northern Railway, Eastern Railway?
Oh, that,
What has been followed?
in fact, we are collecting, my lord, that will place. Now, if your lordship will kindly permit me to page 79 regarding the scope of the work of the present contract and the contract which I am performing, where I do not have the RDSO eligibility. Please come to page 79. A, capital A, somewhere in the middle, my lord, that is no. AC coach electrical attendant shall be under control of railway ACCI on duty. While escorting the coaches, he shall follow instruction given by railway ACCI. Scope of the work of ACCEA includes assisting on-duty railways in the following works. Please come to 1.3, my lord. Assist during pre-cooling at other end to on-duty railway ACCI, escorting staff available in the train 1 hour before departure, etc., etc. Then please come to 1.9. Assist in troubleshooting line failure with on duty railway, ACCI or railway home depot in charge. So amongst others, this is the scope of the work. Now please come to page number 107, my lord. Scope of the work of the present contract which I am performing under the same NF railway. Yes. Page 107, my lord. Kindly see the number 9, scope of the work and job list for AC coach attendant in trains. Then please come to 108. Roman 23 and 25. Page 108. To assist the AC coach in charge in pre-cooling the coach and while providing emergency feed extension cable, etc., etc. To assist the AC coach in charge in rectification of faults
in AC coach equipment, etc. etc. So, my lord, here, number one, the railway board is of the view, my lords, that you need not, bring in original equipment manufacturer because it's not a supply contract, but it's a service contract. And only thing is there to assist the railway staff. The idea is to, my lord, outsource some of the functions. Now, when other railways are following, my lord, what is that good reason? I don't think railway is so rich that they can afford to pay more money because it is the decision of the railway board itself.
I do not know, we'll have to hear them.
No, definitely. All that I'm saying is tomorrow is the last date, my lord. But for some order by your lordship, they
But
will-
this issue was there from since 5 years ago.
No, my lord, this is the first tender after that by NFL. Because the contracts are coming to an end in the next couple of months. And to page 275, my lord. If I so. Now, my lord, kindly see at page
Show me,
275.
where is the bar on the NIT?
Yes, page 32.
Is it online?
Yes.
It's online.
Yes. The page 32 is the bar, my lord. Escorting contract for roof mounted AC package unit for LHB variant AC coaches by approved vendors included in the list of approved vendors issued by RDSO for manufacture and supply of electrical items. In fact, my lord, the list of approved vendors which RDSO maintains, that is of the manufacturers and suppliers.
Naturally, they
and-
want the manufacturers.
No, they don't want. Had it been a case, they could have said that companies' technical men could have, that they have not said. And I am having the electrical license. I have been performing that since 22 under railway. I am doing that 275 page to.
So if you're a manufacturer, you can work even if the machinery is of another company.
No, my lord.
If
I
the
am-
AC
if
is
I
of,
am a manufacturer of X company, my lord, then I can also repair it. But that is not the job.
no, that is what I'm asking. If the railways of that train has AC of say Samsung AC.
Okay.
So higher technicians can also act as, they can participate. So it doesn't have to be the manufacturer of that company, the employees of that particular company whose AC is on the train, that needs to be working on that train,
So,
correct?
look,
Can be somebody else,
my lord, perhaps I have not been able to clear to yourself. My lord. What I am trying to say is it's a service contract.
correct?
For service contract, why you need a manufacturer?
No.
Because the list is of the approved
No,
manufacturer. List is
Why?
of the approved manufacturer. Well, any service provider can do.
No, but then,
exists-
what about the distributors and the suppliers?
They are to the extent of, my lord, supply. Distributors supplies on behalf of the OEM.
But then they do the servicing also.
Yes, they do this, but it's not a contract for servicing. It's a contract, my lord, an ongoing train. There, my lord, we have to escort the AC coaches, where we'll do some assisting, we'll assist the on-duty railway inspector.
Actually, and one thing is if the ACs go bad, then you have to repair them.
Yes, little bit. That for that electrical license we have.
No, my question is, supposing the train, you see, there are different companies making ACs. Now, supposing the train
They are
has
not
got,
restricting it to a particular. company.
supposing the AC is of say Samsung AC, a technician from another
Say Tata
company,
product.
that he can participate, is it?
So our only limited queries, well, I am not saying that court should be awarded loss. So examine this and regarding other railways position. And in fact, my lord, recently your lordship that judgment in that transport thing, my lord, where they were insisting on some other document where we have given the receipt, lordship has allowed that petition. That vehicle, my lord, that we could not produce the RC. So we gave that alternative one. Their lordship has taken a liberal view in the matter. Something like that. I don't know.
Let's see, yes.
There must have some justification for lordship, incorporating those conditions, lordship. And it being the prerogative of the tender authority, lordship, to incorporate.
That is there. Only thing is that why Southern Railway has allowed,
But that letter is of 19, and the Southern Railway letter is of 2021. By this time, it might have changed. And tomorrow is the last day, the last moment they came. Otherwise, something could have.
No, but it was of November 10th. They filed a representation in, I think, 14.
And my lord, as of November 2022, my lord, I have got a work with the old condition, page 275. I'm continuing that job. Still valid, my lord. They continue, they did never insist. 275. And see, my lord, the service description. Custom bid service, so and so, outsourcing of AC coach attendant for AC escorting operation and troubleshooting duties for 2 years. Tenders should be quote rate at par or above the schedule of rates if a tender. So this is the contract I'm doing under the old condition. Presently, I'm operating this contract. No, my lord, the period is expiring in November 2024 for 2 years. Presently, I'm doing this. So there they never insisted on this clause, 22. Yes, please. If your lordship would kindly come to 305 Miller, that's the qualification criteria. I'm sorry, Miller. Oh, 322. Page 324, Miller. Page 324. Similar work means minimum eligibility criteria, escorting, operation, troubleshooting of RMPU in AC coaches, annual comprehensive or so and so, or so and so. Page 324. As of November 2020. Similar work means. Escorting, operation, and troubleshooting of RMPU in AC coaches.
This is for what?
In November 22, Milord, this tender was issued and I got it. I'm performing it on November 2024, another 1 month.
But whether we can interfere?
No, my lord, I'm saying lordship will subject to further orders. Lordship will only allow us to participate. Otherwise, they will not entertain my tender. Possible examine if your lordship finds, substance, lordship will allow. Otherwise, lordship will dismiss the writ petition.
And the prayer is to modify the tender conditions. Whether that will lordship we can do.
No, let us. He said 226 proceeding. We are not in a civil suit. A better draftsman can put it in a better way, but that will not deprive him of the relief.
And we learn with each passing day, lordship. That's why the tender conditions are changed with the need of the hour, lordship.
Well, definitely this clause is not in public interest, having regard to the observation of the railway board. That is an aspect of which lordships can definitely take judicial notice. Because the railway board observation is when you engage OEM for the job, they charge hell of a lot. That is why they have given the option.
Only thing is, you see,
only I will participate, Milord. They will only accept my tender regarding within 2 weeks, Milord will try to come up with all these things. Lordship will fix a date and then permit them to go ahead. Only for permission to participate.
What has happened to other railways?
That's why I'm saying, you know,
Western,
as
we
of
have-
now, we've been able to come up with a Southern Railway. Others also will place them. Depending on that,
You have to obtain instruction.
yes,
What has happened to Northern, Southern, after this 2021-19 decision? What has happened? And why you now
incorporated this.
incorporating this new clause?
Only thing is, my
I
lord,
can understand the reason. It's because
it
it's
is more as
the
a first
persons who know the machinery
Lordship, if
can do
it
it.
more as a first item, Lord.
I can do that, no problem. Right. Heard Mr. K. Chaudhary, let us see the counsel for the petitioners, assisted by, no, petitioner, assisted by Mr.
G. Goswami.
G. Goswami. The petitioner's case is that the petitioner has been involved in the work of attending / escorting and distribution of bedrolls in AC coaches under the NF Railway, having electrical license issued to the petitioner by the Telangana Electrical Licensing Board. The railway authorities used to issue a single tender for the work of escorting AC coaches and bedroll distribution. However, the NF Railway has separated the above two works and floated two tenders. The petitioner is aggrieved by not being able to participate in the tender number, in the tender dated tender number EL-GH-965 dated 1/10/2024 for the work of outsourcing the job of ACCEA. What is that? ACCEA?
29. AC coach, electrical,
Huh?
AC coach,
AC coach,
air condition coach, electrical attendant,
air conditioned coach,
electrical attendant.
electrical attendant, AC coach, air conditioned coach, electrical attendant, bracket ACCA, for escorting of LHB. What is LHB and SD? For escorting, for escorting AC coaches.
Ah.
For escorting AC coaches for 4 years. Full stop. However, the said outsourcing of the job of ACCA requires the tenderers to be a manufacturer and supplier of electrical items, which is recognized by the RDSO. What is the RDSO?
Research, Design and Standard Organization.
Research, Design and Standard Organization, RDSO. What have I said? Last paragraph. Not, we don't say which is recognized, we say which is in the list, which is in the list of approved vendors issued by the research and so on, RDSO, for manufacture and supply of electrical items. Next paragraph. The petitioner's counsel submits that the railway board in their letter dated 17/1/2019 had authorized the principal chief mechanical engineers to relax the set condition to ensure wider participation with a view to obtain lower rates. And in this regard, the Southern Railway had done away with the said clause via letter dated 24/12/2021, issued by the headquarter office, Southern Railway. He submits that the said clause should be done away with in the present tender dated 1/10/2024. And to allow the petitioner to submit his tender. The last date being 23/10/2024. Mr.
E Chakrabarty.
D. Chakrabarty, the learned CGC, submits that he will obtain instructions by tomorrow. List the matter tomorrow.
Well, I may be given liberty to make a mention. If not, I can-
In the
Yes.
morning. Yes. Later. List the matter tomorrow. Let's take it up tomorrow.
Sir, Shantanu Bose is here. He's a DGM Commercial and Revenue.
Okay. Yes, you were speaking of which page? 57.
Bill is at page 67. And 57 is the final report bill.
No, page 66.
Page 66 is the bill.
So your case was that the contract related demand of the petitioner was for 783 kVA. Correct. And which was equivalent to 6665 kilowatt. Now, in terms of the discussion held in page 56 and 57. 57, please look at 57. It says here in bold, as per discussion in the revenue meeting held on 24/5/2016, in the office of the CEO, DEC, APDCL, WL, the load survey of the above consumer is verified and found that the total load is connected with the APDCL electrical network. Total load found to be 907,658 kilowatt. Old unit with modern processors. So total equal to 1507 kilowatt against connected load of 831 kilowatt. Oh, could you just explain this bold?
Yes, sir, sure, sir. My lord, actually 1507 is the detected load. That means the total installation. If we calculate the machineries or loads found connected one by one and add it up, so the total figure comes as 1507.
That is the amount of electricity it would consume. Is it? No.
Actually, sir,
it is the
it is the
load.
installed capacity.
Okay, installed capacity.
So he has actually exceeded his installed capacity, and by way of which he can use additional loads.
His installed capacity is how much?
Sir, his installed capacity is detected installed capacity is my lord 1507, and actually he availed, my lord, that connected load of 831. That means he was sanctioned 831 kilowatt of load on record, on paper.
But he used 1507.
Yes, actually he connected additional 676 load.
He's saying
Yes, sir.
that his load is not 830. So he says that but load is different from contract related demand. That's different, is it?
Actually, my lord, contract demand is a separate agreement, contract demand agreement, which is executed with APDCL, wherein the consumer declares that maximum how much
He will
KVA
use.
he is going to use while using connected load.
So his case is that his contract related demand was 783, his case. So his case 783, and now uh, when you come to page 66,
Yes, my lord.
you come to the middle portion, meter reading details.
Yes.
Then you come in the bold, it is written RD KVA. What
Yes,
is
my
RD?
My lord, RD is the recorded demand.
Recorded demand.
That means the demand which is recorded in the meter.
Okay.
So actually, that is the recorded demand again is to be multiplied by the multiplying factor. Here, the MF, you will see, my lord, one column is there where MF is written, no? So that MF,
Yes.
yes.
1500.
So you need to multiply MF by RD
Okay.
to get MD, maximum demand.
Okay. So he's saying, you see this RD is there, then MD is there, KVA. And then you see BD, billing. He says BD is billing demand. Correct.
Actually, sir, my lord, billing demand is the actually billing demand will be the contract demand which is executed with the
Okay.
consumer.
So this is not so what he was trying to tell us is that this billing demand shows that it is 783. So what he has consumed was less, is not more than 783. Is that correct? It is, or does it only show that this
My
is?
lord, actually, if you allow me, then I can explain.
Yes,
this.
please explain. Please.
My lord, suppose one owner is there and one tenant is there. So the owner has agreed to give the tenant 1,000 square feet of house, and he allowed him to stay there for a rent of say 10,000 per month.
Okay.
So now, after certain days, the tenant again approached to the owner and said that, sir, I will not use the total 1,000 square feet of land. I will adjust in 700 square feet of land. So I will only use while using. I'll stay in 1,000 square feet of land, but while using that land, I will use only 700 square feet. So please reduce my rent. So then owner again entered into a separate agreement with the tenant. Now, what tenant did is, so he has a total square feet of 1,000 square feet, and he is staying in a 700. While using it, he is using maximum 700 square feet. After certain days, what he did, he actually made another room by the side of the 1,000 square feet of land, which was allowed him to stay. And then what he did, he is now using 700 square feet of land, but while using it, he is surpassing that 1,000 square feet. And now he is able to, by way of extending that land. So what he is able now, earlier he was not able to use the adjacent plot of land. Now he is using the adjacent plot of land. But he is saying that while using it, I am using only 700 square feet of land. I am not using more than that. But actually, he has occupied total of 1,500 square feet of land. So this is the scenario here, sir.
No, so I just wanted to know, in this page 66, that MD KVA 783 and BD KVA 783, this is not any measurement or anything, no? This is.
Sir, actually, my lord, it is not actually related to the actual clause. Actual clause is saying that if your total, what is the definition of connected load? The definition of connected load is if I sum up all the accessories which are installed here, I will get the picture of connected load. Now, here the clause itself is saying that if
if you are, adding some additional load due to which your connected load is exceeding,
Ah,
or there is any chance of exceeding your total connected load, then you will be penalized. So here, there is nothing about the, how much power you
Using
use
nothing
while
is there.
consuming power. So it is not related to that.
Not really.
It is related to the total connected load. If
Load.
you exceed total connected load by adding up extra
So
loads,
this
so you will be
783.
penalized. Simple, sir.
So this MD KVA 783, BD KVA 783, this only mentions what is the total load,
This is
connected load.
this is actually, my lord, while consuming, as I told you, yes, what he,
This is entitled load, but it is not, it does not show whether he used this much load or did not use this much load. It is just
Yes. Yes.
entitled.
yes.
Your lordship may kindly come to page 17 of the booklet.
No.
What is the penalty
You see one thing,
below?
just a minute. When you had taken us to page 66, you had told this court that this MD KVA and this BD KVA, which shows 783, this is the measurement, this is the reading.
Yes.
He says this is not the reading, this is only your entitled load, this is not the reading of the
Your
electricity
lordship, there-
consumed.
He is making wrong statement. Their affidavit says, your lordship may kindly come to page 11 of their affidavit in reply. Para 11, page 93.
Para 11,
Yes, Miller.
there is, para
Last
11,
three lines.
11 page,
Affidavit in opposition, page 93, internal page 6.
page 90. Yes,
Last three lines. Further, any quantum of consumption
just a
maximum,
minute, which para?
para 11.
Further, no, wait,
Yes.
That with regard to the statements made in paragraph 30.
13 of the read petition, the deponent respectively states that the load survey was done as per the APDC norms and it was found that 1507 kilowatt of load was connected with APDCL network.
But
Further-
where is it? Where is it? 1507.
That is the load reflected in the inspection report.
So there.
Yes. Now, further, any quantum of consumption maximum demand in petitioner's factory drawing power will reflect in the meter. That means whatever load I will consume, that will be reflected in the meter. And this 783 is the load which is consumed by me. Your
No,
lordship-
it just shows the load that is your entitlement.
No, this is the maximum demand what I have consumed, my lord.
No.
Your lordship may
No.
kindly complete this provision.
In page 66. Yes, Mr. Officer, in page 66. Come to page 66.
Okay, 66, yes,
Yes.
yes, my.
Where is the column showing the amount of electricity consumed by the petition?
Electricity consumed by the petitioner is actually
You can
my
come to
lord,
page
ID,
65 and
recorded
66.
demand is the demand shown in the meter. That means the consumption.
Where
which
is that? Where is it?
RD KVA, under the heading RD KVA, 0.52 is there, no, sir, my lord. So 0.52, if you multiply it by 1500, then you are getting 780.
0.52 multiplied by
1500.
1500. Yes. You're getting how much?
780. And his
780.
yes,
780.
780. And his contract demand is 783 perhaps.
Correct. So then,
So on that contract demand, I'm realizing the fixed charge.
so he's not
Exceeding.
he's not going beyond 783 then.
This is for the entire month.
Sir, actually connected load is, sir, here it is written clearly that if you buy addition of additional equipment.
So you see, it's like that. Supposing they're different equipments, extra he bought, say later on. When you add it up, his connected load might be high because of this. But then what is the actual amount of electricity used?
Sir, actually, there are some procedures to be followed before you add additional load to the network. So you need to take the permission of the electrical inspector, and then you need to apply before the licensee. The licensee will check, and he will give the load clearance certificate. So after that only an agreement will be, a separate agreement will be executed, then load security will be provided, and then the meter CTPT set will be upgraded. After that only he is allowed to add any extra
So,
load to the
what you're trying to say is, depending upon the load, the total load, then the multiplication will be higher or what?
multiplication will be
Out here it is
yes,
1500.
we provide
If the
generally we
load becomes higher,
yes,
will will this RD KVA
yes,
will be multiplied by a higher number or
higher MF,
higher MF?
higher MF.
Higher MF. Oh, okay, higher
So
MF.
entire setup will be changed, sir, my lord.
Okay.
Higher rating CTPT set will be
So
required
that,
to be
okay,
installed.
according to you, so once RD KVA is the RD KVA will be the same, but the multiplication by this MF will be different.
Yes.
Is it? What is MF? What does MF mean?
Multiplier factor that
Multiplying factor. So is the multiplying factor, does it become higher if the load is higher?
if
the
the load is
connected
higher,
load-
multiplying, we need to install a higher rating CTPT set. So
What is that?
multiplying factor will be again higher.
So according to you, the connected load was how much?
Connected load was 831.
1507.
No. Sir,
No.
Sir, initially he was sanctioned 831 kilowatt load. But later on, when inspection, we found 631 extra load in his premise.
Acha, besides 831.
Yes.
So,
Over this load
so
was over and
831 plus 600 and
677,
676. This much
So,
extra load was
extra load. That means it comes to 1507.
1507.
1507 was the connected load.
Connect.
Now 1507, the connected load, how much will be MF be? MF will be how much?
MF will be, sir, I need to calculate it.
What the then applicable supply code says, the definition of connected load, as per the supply code, for us it is easier to go by this definition. Connected load means the aggregate of the manufacturer's rated capacities of all energy consuming devices connected with the distributing licensee means in the consumer's installation and which can be simultaneously used. Regardless of use, which can be used.
Simultaneous.
And the definition of unauthorized use.
No, that is all right. That is all right.
So even if he has not used it.
No. You see, the issue is this.
Sir, for use another contract demand agreement we are executing with the consumer, that while using power, you will not exceed this much kVA.
Correct.
But the original agreement, it is 831. So, and later on, he has come up with a proposal that, okay, I will not, my installed capacity will be 831, but I'll at a time while using power, I will not use that much. I will use only this much.
But
So
in
for
fact,
that-
he went right higher.
Yes, but he has added, he
More
kept
than
on
the
adding extra
connected
loads
load
to the
also.
network.
He has added it without our permission.
Without our permission, without any proceedings to be followed.
That is why I want to know the MF. Because
Sir,
what
sir,
he's
I'm
trying to say.
calculating it. Just give me 2 minutes time.
So MF will solve everything then. We'll calculate this 0.52 with the MF.
In the meantime, Milord, may kindly.
No, my brain is such, it takes one thing at a time. You're the expert in electric.
No, Milord.
thing. We're just,
Milord,
we are, still having that milk from the milk bottle.
Perhaps my,
So-
so will correct me if I'm wrong. Perhaps that requirement of calculating the MF with the 0.52 may not be necessary because 0.52 is the actual consumption.
Correct.
Now, unauthorized to
for it to be unauthorized use of electricity, he did not have actually consumed electricity. The bill reflects the actual consumption during that period. But the act of unauthorized use of electricity, your lordship, it is committed when he connects it, your lordship, regardless of use.
Regardless of use.
Because
regardless of you. Oh,
Total
okay.
tune of load is changing.
so he
Okay.
might have used it as, but because if he switches on all of them, the entire the grid will collapse. That is why we are very strict about who connects what.
Yes. Correct.
So the definition is important.
I have given the copy of the supply code. to your
Your
lordship.
lordship may kindly take up.
Just a minute,
Page-
one at a time.
That is given below.
No,
That is given in the booklet.
Sir, MF will be 2000.
MF will be 2000. So 0.52 into 2000 will be 1000.
Yes.
So 1000 is above 783. Either way,
Your
you're
lordship may kindly take up their provision.
okay.
Your
Wait,
lordship
wait. Before that, the
Lordship, the definition of connected load, your lordship will find at page 1189.
1189.
1189, third page. So 1.3 sub rule 50. Connected load means the aggregate of the manufacturer's rated capacities of all energy consuming devices connected with the distribution licensing means in the consumer's installation and which can be simultaneously used.
And which can be simultaneously. Okay.
This shall be expressed in kW, kVA or HP units and shall be determined as per the procedure laid down by the licensing with the approval of the commission as specified in these regulations. Then unauthorized use of electricity, lordship will find the definition. At page number 1221, your lordship. So 1221, clause 5.8.3.2. Subject to the generality of the above cases mentioned hereunder shall be generally treated as malpractice. B, your lordship, exceeding the connected load authorized by the supplier.
Okay.
So he 5.3. So regardless of actual use, very act of connecting it to the mains itself constitutes an act of unauthorized.
So whether you use it or not doesn't matter.
Sir,
And in fact,
sir, another clause is there, 5.3.
5.3.
My lord, 5.3, it clearly says that if as a
Page 1219.
1219.
1 to
19.
1 to 2 1.
1219.
19.
Please refer to another clause.
Yes.
It is, the heading is, my lord, extensions and alternations.
Yes.
So load extension and alternation. So what should the consumer at any time after the supply of energy has been commenced desire to increase the number or size of lights, fans, motors, etc. in his premise or in any way alter the position of his wiring therein, notice thereof and need to change the connected load if any shall be sent in writing to the licensee prior to adding such load to the network, sir. If as a result of such proposed extensions and alterations, there is possibility of an increase in connected load over the sanctioned demand, the consumer shall take steps to submit requisition for additional connected load. Failure to regularize the increase in connected load may result in billing at penal rates as provided for under the rules and also result in disconnection of supply after due notice. So it is clear, it is very clear from clause 5.3, Your Honor, that the consumer has to follow up all the proceedings prior to adding such load to the network, which results into extension of load over and above the connected load.
So at the time of making the initial connected load, those equipments or machinery might not have been there.
Yes.
It was later on found that it was there. though it might not have been in use, the fact that those machineries were to be connected or informed had not been done.
Yes.
And because it could have been used
Have been
simultaneously.
used simultaneously.
So, and once it was to be used, the connected load became higher, due to which what is that,
MF,
MF was to be
higher
have
capacities.
higher calculation thing. But where do we have, where's the connection between this MF and this higher load capacity? That multiplication, where do we get that?
Sir, for that, I have to provide you that booklet which we have. I have not carried it with me.
So that says that when there is a higher connected load, then the multiplication, the
MF will be higher.
the MF, what is the MF? MF means what?
Multiplying factor.
Multiplying factor. MF multiplying factor will be higher. As per what book? As per what code? Is there any code or something?
Actually, code is not there. We have our technical calculations. One
Okay,
chart
it
is
is there.
there
Okay.
available with our PPND wing. So I need to collect it and will submit here.
Okay, so that is that. Okay, no, thank you so much. But just wait, huh? Because just listen. Now we have got to hear the other side, the expert now.
Your Lordship, may kindly check up section 126 of electricity.
126. Is it hot? Yes.
Mary. If on inspection of any place or premises, or after inspection of the equipment, gadget, machines, devices found connected, or use, or after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity. He shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited by such. Now, my lord, the condition precedent for invoking section 126 is twofold, my lord. First, he must record a finding that the consumer was found indulging in unauthorized use of electricity, which has resulted in some benefit to the consumer. This is the first. And second one is that he must make a base judgment assessment. Now, the assessment cannot be based on any formula, straitjacket formula. Now, your lordship may kindly come to page subclause B of subsection 6, explanation B.
What of this?
Yes, my lords. Section 126, subsection 6, explanation B.
Yes.
Unauthorized use of electricity means the usage of electricity. So it is the actual usage which is made penal, my lord.
Correct.
Now, your lordship may kindly come to the booklet.
Just a minute. But 6 talks of assessment.
My lord.
6 talks of assessment. At the tariff applicable. The assessment under this section shall be made at a rate equal to twice the tariff applicable for the relevant category of services.
There is no dispute, my lord, regarding that. The first and foremost thing is that he must record a finding that the petitioner was found using electricity unauthorizedly. That is not there, my lord. Your lordship, as in there is no finding. And
no, but the fact speaks for themselves.
No, my lord, there is nothing. He is simply noting down the ratings of various machines. Now, your lordship may kindly come to page 17 of the booklet, my lord.
Page 17.
17 of the booklet.
What booklet?
I have provided, yes. This is the provision for making assessment for theft related cases. my lord. And what does it prescribe? You will also may kindly see it. Close 5.A.4,
Page.
page 17. my lord.
Yes.
Method of assessment of electricity charge payable in case of theft pending adjudication by the appropriate court. Where a consumer is found to be indulging in malpractice with regard to use of electricity and use of device to commit theft of electricity, the authorized officer under section 126 of the Act may, without prejudice to any other action that may be taken against such a consumer, ask him to pay compensation which shall be assessed as stated herewith. Now 5A41 will. Maybe,
This is the same book.
yes, please. I have given the relevant portion. Use 5A41.
Yes.
Use of unauthorized electricity, load exceeding authorized connected load, metered load. Your lords may kindly mark it as metered.
Yes.
So this provision can be invoked only in case, this penal provision can be invoked only in case the metered load is found exceeding the authorized load. There are three judgments, my lord, I have given there.
So your metered load.
Is not found.
No, but then because you did not report that these are the
No, no,
equipments
my lord,
that you have.
Because whatever electricity I will consume, that will be reflected. They have admitted in their.
No, Mr. Counselor, that's sorry. What you have consumed is there. But the problem is because you did not report your subsequent load, the multiplication, the multiplying factor has not been corrected. So you're consuming electricity
Lord,
to your advantage without paying for the same.
Lord, as far as connected load is concerned, I may have various machines and motors. But it is my duty to keep my load within the permissible limit, that is the authorized load. That is the requirement under the law, because to make it penal, it must be shown in the meter that I have used. Then and then the question of making any payment. Because so long I am.
What was the equipment that was found?
The list is there, your lordship. Equipment list, your lordship will find at page number 54 onwards. So 54, 55 and 56, your lordship.
What is this lower trough? All this?
These are machines used in the tea industry, your lordship. Lower trough, upper trough, CTCs, dryer, sorting, spot humidifier. Then again at page number 56 also another list of equipment is there. And he has admitted in his pleadings itself.
So the basic thing is that he has been paying, he has not been paying his tariff
Yes.
as per the rate that should have been made, as per the required rate.
Yes, he has been exceeding his authorized connected load.
He has exceeded his connected load,
Connected load.
which leads to, which required that the multiplying factor became higher.
Yes, in fact, what
And even though his electricity consumption may be lower, but the rate by which he's paying his electricity is lesser than what he should have been paying.
yes, in fact, he had, in this case, he had applied for increase of his connected load. And for an increase, enhanced load security has to be paid. So that came to around 35 lakhs odd.
We gave him a bill for payment of the enhanced load security bill. In the pleadings, he has admitted that he did not have the financial capacity to make that payment. So since he did not make that payment, the application was never approved. That is the part of the pleadings.
Where is that impugned order?
Your lordship may kindly come to page 34 of the packet.
Huh?
I will refer to 3 judgments of their authority, my lord. One judgment is by the Assam Electricity Regulatory Commission, who framed the supply code. This supply code is framed,
I'm not on the law. I'm just on the facts.
my lord, the law is settled in this petition.
Assam Regulatory
In
Authority
fact, your lordship,
is not
why-
higher than the High Court, sorry.
Your lordship may kindly turn to page 36
Just a
for
minute.
a moment, my lord.
Yes, what?
why the petitioner is so he's insisting here that the matter should be decided, because if he goes before the appellate authority, there's a statutory requirement of depositing 50% of the assessed amount.
And after that, where is the appeal after that?
After this, your lordship, he has a statutory appeal under 127. If he is agreed by that order, then he can come to the writ court.
Oh, then you can.
Then,
consider.
in fact, several matters your lordship has had the occasion
My
of.
lord, I will place one judgment recently decided by your lordship. Your lordship has remanded the matter, directing the appellate authority to decide as to whether by reason of the tempering the any consumption was reduced. He has not decided. I will place my judgment.
He has not decided.
No, my lord.
The appellate authority has not decided. That is a different issue.
is a
He has not
different issue.
decided, that's a different issue. Yeah,
He has to decide.
He has to
either.
decide if he doesn't.
Pinpointed your lordship has made, your lordship may kindly for the time being.
It's a council. If he
You
has,
are not deciding.
what to
Because
do? What to
your
do?
lordship-
We pass orders
Lord-
for payment of contractual dues. They are not being paid. So what to do?
my lord, your
Does it
lordship-
mean that?
Your lordship may kindly take up para 9 of your lordship judgment. Para 9.
It's a statutory authority, your lordship.
This was the direction given by your lordship. And he has not decided that any load was.
We know then you come here again and say that he
Your
has not
lordship may-
decided.
Your
Or
lordship may kindly. Here for a moment, my lord. The petitioner has approached the assessing officer. Now, if the jurisdictional issues are raised, and I will place one Supreme Court judgment in covered by this case, which is covering this case, my lord. In that case also, my lord, the load was found, the petitioner was found overdrawing the electricity. I will take your lordship to those judgments, my lord. Your lordship may kindly first come to
I'll give you, you're relying on how many judgments?
4-5 judgments.
What 4-5? From 3 going to 4-5?
Lord, I have given, my
I'm
lord,
not listening.
my lord, I have given. Your lordship may kindly
What is
come.
this?
come
You,
to page
you-
36.
you see, let us not waste time. No, that's one thing I don't like to do. And there's no point, harping on one point by giving 3 or 4 judgments. If it's 1 point, 1 judgment is enough. No need of giving 2 judgments. So please do not try to waste the time of the court. You'll find that there are more ways than one to finish off a case.
Your lordship may kindly take up page 36. I will take your lordship to the relevant portion of the judgment.
Page 36.
Yes, my lord, the booklet me.
You see, this case, there is a alternative remedy available. Why aren't you going there? Then you can come here again. Because straight away, what appears and what can be seen from here is that the connected load that you had of 831 kV or kilowatt, what do you call it? Now that has not been enhanced due to your not reporting your additional equipment. Now, because of your not reporting that additional equipment, your connected load has not been revised, due to which the multiplication factor, the multiplying factor, which is to find out how much you are to pay for the electricity used, has not been correctly calculated. You have been paying a lesser amount.
Because,
That's what they're saying.
my lord, whatever load I will consume
Huh?
and whatever the recorded demand, that will be reflected. If I use excess connected load, that will be.
Correct. It will be reflected, but the multiplying factor will be changed.
Yes, accordingly, that will be reflected from the multiplier factor as well as the
Because,
RD.
because
But RD is not there recorded higher. RD is within the 783 kVA. That is within 783 kVA. It is not that I have exceeded 1000.
okay, so I can understand your case is that once if your RD is within that 783, that demand, then the multiplying factor, even if their connected load becomes higher, does not change.
That will not change. Sir.
So your case is that if the connected load, if the RD goes beyond your demand contract, then only the multiplying factor can change.
If RD will change, then my contact demand maximum demand also change will. That will also change.
Don't try to confuse. Yes,
It will also change.
please explain. He's saying, page 66.
You're on a total installation.
This RD KVA is only 0.52. And his page 66. His RD is 0.52. He says that unless and until the RD comes to this contract related demand comes to 783 or above, beyond 783. Until then you cannot change the multiplying factor. That is his case. He's saying that the connected load is not the determining factor for making the multiplying factor.
No.
Lord, my learned friend will admit multiplier factor is fixed based on the CTPT ratings.
What is
as-
CPT rating?
CTPT is the current transformer and potential transformer, which is fitted at the top of the metering unit window. And the three-phase meter, it is the specification of the.
Yeah, you see, the problem is we are not talking in very simple language.
I will.
For which is confusing me. That is why I have got to talk to those persons who speak in more simple, plain language, which I understand. So I'll ask them.
What my
Because,
lordship explain to me, your lordship, is the connected load, let us say it's 500, it's 100. If it becomes 150, the capacity of the transformer has to be increased. So otherwise the grid will collapse.
Correct.
Now, as per the current transformer, because he did not actually use it, which is saying.
So it did not collapse
did not
or whatever.
But
it has to be counted.
if the capacity of the transformer is increased, correspondingly the multiplying factor would also increase. Here, what my learned friend is trying to project, your lordship, is that use of electricity is the same as consumption of electricity. He's
Yes.
saying, since I have not consumed, I have not used.
Correct.
The words are use and consumption are two different words, your lordship. So they cannot be interchanged. The law penalizes unauthorized use of electricity, not unauthorized consumption of electricity. He may not have consumed it, but what the law penalizes is the act of connecting it to the electricity mains, your lordship, without approval of the license. So that is the case he's trying to do.
Okay.
Another.
Yes, I think I've heard. No. Yes, anything else?
My lord, another important point I would like to project here, that as it is submitted here, that irrespective of whatever load I keep on installing on a day-to-day basis in my premise, but while using power, if I stay within the contract demand, then I'll not be penalized. So if it is assumed to be true, then today I have an industry here, I have an industry set up here, side by side tomorrow, I can keep on adding load and I can set up another new industry here.
Correct.
And I can use the load by switching the load from here to here, but keeping while using power, keeping the load within contract demand. So that is not allowed, that cannot be allowed, my lord. That kind of submissions cannot be allowed, my lord. Thank you.
Your lordship may kindly take page 28, that is the Supreme Court judgment, relevant paragraph 67. page 28.
Page 28, yes.
This booklet. I am referring to relevant paragraph 67.
Yes.
On the cumulative reading of the terms and conditions of supply, the contract executed between the parties and the provision of 2008, we have no hesitation in holding that consumption of electricity in excess of sanctioned connected load shall be an unauthorized use of electricity in terms of section such and such. This we also say for the reason that overdrawal of electricity amounts to breach of the terms and condition of the contract and the statutory condition. Besides such overdrawal being prejudicial to the public at large, as it is likely to throw out of gear the entire supply system, undermining its efficacy and efficiency and even increasing voltage fluctuation. So, consumption, if I consume, then this will be unauthorized. That is what has been held. And for that, I am liable to overdrawal penalty. I have shown to your lordship, page 17, my lord. There is a provision for overdrawal penalty. That has not been levied. Your lordship has seen, page 66. There is no column levying any overdrawal penalty. So I have not consumed any excess loads as has been.
That is not their case. Their case is not that you have consumed or you have overconsumed. The case is that you have not paid that by hiding. You have not paid the correct rate
For that
because the contract load, the connected load has not been revised.
For that, there must be provision for levying penalties. There is no provision. That extension of load simply amount to unauthorized use of electricity. Your lordship may kindly.
And next case.
Page 36, your lordship.
Page 36.
Page 36 only.
Yes.
This is the order given by Assam Electricity Regulatory Commission. Your lordship may kindly take clause C, 9C.
Yes.
Where in case of consumer equipped with MD meter, that is maximum demand meter, the licensee shall compare the MD reading with contract demand, and if load exceeds the contracted demand, then the penalty at 3 times the normal tariff shall be levied as per provision of schedule of tariff. Clause such and such regulation will be applicable when unauthorized use of electricity is detected by the assessing officer. Excess connected load cannot be termed as unauthorized use if the maximum demand record shows otherwise. Thus, this provision of 742 under AERC Electricity Supply Code regulation will be applicable only when there is no record of maximum demand measured through MPM. In such cases, connected load will be the contracted demand as per. Now, your lordship may kindly see another judgment, page 39.
Excess connected load cannot be termed as unauthorized use.
Yes, my lord. Your lordship may now come to page.
If the maximum demand record shows otherwise.
My maximum.
So what do you mean by maximum demand?
That is my maximum demand shown is 783. My lord. That is within the connected load.
Have you got this document? Have you got this?
Now, your lordship.
Just show it.
Your lordship, I am placing one more judgment
Yes,
in
yes,
which
yes.
my learned friend appeared, my lord. Page 39.
Excess connected load cannot be termed as unauthorized use. Page 36.
Lord. This order. After 8/10/2018, one amendment was done to the supply code of AERC, which was published in 2017. So, hide that amendment, these modifications were brought to. But the thing is that it is a case of 2016, which comes under this terms and condition regulation 2007 of supply code.
And this is a case of 2019. That means after publishing of the new supply code.
Okay.
It is a case of 2000.
No, this is orders of 2018. No, this orders of 2018. So the new supply code came into effect when?
2017.
2017.
Notified on 6th of November 2007.
On 6th of November 2007. So that is, okay, so this 7.42 has been changed.
Changed.
So earlier in the 2016, it was different.
Yes.
In 2007, it was different. 7 or 4?
2007. It
Seven,
was amended
okay.
in 2007. Originally, this was 2004 million. And that was applicable up to 2017, when the new supply code has taken place here.
Okay.
Now,
Then
this 2016 prior amendment is also taken care of, page 39 of the booklet. In that case, my learned friend appeared.
yes,
Last two lines, page 39.
yes.
As per section 126 of the Electricity Act, it is the actual unauthorized usage by the consumer which resulted in some benefit to the consumer, which is liable for penal bill. But there is nothing in inspection report dated section to establish that the petitioner was found indulging in any actual unauthorized use of electricity resulting in any sort of benefit. As such, I do not find any wrong on the part of the APDCL in not issuing any assessment bill on account of alleged malpractice. As per clause 5A which is relevant for this case, my lord. As per clause 5A(4)(1) of the Assam Electricity Regulatory Commission Electricity Supply Code and Related Matters Regulation, penal bill can be sustained only if the metered excess load, unauthorized load is detected during inspection. But mere extension of load without any actual use cannot be penal. Again, as per clause 742, that is perimetria to the clause 5.A.41. And they have, in that case, my lord, they have not issued because my maximum demand reflected in that case was below the contract demand. They have not issued any bill.
Yes.
My lord, this case was, the consumer again appealed before the appellate authority. This, ombudsman, and there actually the case went in our favor, and the final order is there with me. And we issued him the final bill amount as per the order of the ombudsman, and we realized 4 lakhs rupees. So there was
So
some
he has
modification.
changed
Yes,
this order.
ultimately the consumer had paid 4 lakhs of penalty. So I have all the case details. If required, I'll submit.
But this is the judgment of the ombudsman.
Yes, 25/9/24.
Then-
Full judgment is with me. I will support.
Purvanchal Singh. Oh. I was talking about Simpec. Okay, Simpec.
It is the full judgment, my lord.
No, this was related to Simpec Finance. I am talking about Simpec Finance Limited. This is Purvanchal, but here actually.
In this case also, my learned friend also appeared, as well as learned advocate also appeared. Their name is shown in page 1.
Here, the facts, since my learned friend is so harping on who has appeared, who has not appeared, I'll just give the facts of what has happened in that case. That case, what had happened was APDCL issued a bill, consumer had then paid the bill, then audit raised an objection, the office of the accountant general, saying the formula that you have applied it wrongly, so correct the formula. We issued a corrected bill on the basis of the objections of the audit. That consumer used the alternative remedy provided under the act, went before the ombudsman held the original bill was not without any, it was correct, and therefore kindly, but the ombudsman only looks at the amount of the bill. Here, The ombudsman is not the 127 authority under 127. That is a separate authority. Very well, the authority under 127 may come to a similar finding. But without approaching an authority,
It was not a case of unauthorized use of
it
electricity.
was not a case of unauthorized use of
It was not a case of unauthorized.
there, the bill was revised because of objection of the accountant general. In fact, if these are all issues, your lordship, though my management keeps calling them jurisdictional issues, to be a jurisdictional issue, the officer who has issued the bill, he should have acted without any authority. Now, that is not his case. He is saying that the quantum should be different. These are issues which can very well be decided by the appellate authority, your lordship. Mainly calling an issue, your lordship, jurisdiction issue does not make it.
Correct, correct. Yes.
There are two more points. If your lordship kindly permit. The contention that I use connected load to the extent of 1507 kilowatt. That is also on the face of their affidavit, that is not possible. Because I cannot use, your lordship has seen, it is the meter use which is made penalty. If I exceed the meter connected load, then I will be liable for penalty. Now my transformer capacity itself is 1000 kVA. So how can I use below to the extent of 1507? Can't be below. They
No,
can,
no,
neither they can
no,
supply
no.
nor.
They
I can-
are not saying that you use 1507. Did they say that you use 1507?
So if they have not said, then there is no question of issuing any bill, my lord. That is what has been held by the AERC as well as the ombudsman, that it is only the meter use which is made penal. Mere extension of load is not penal, my lord. That is my submission.
But then what about the submission made by them that depending upon the connected load, the multiplying factor will be different? Is that correct or not?
My lord, whether they have issued, they have.
No, I'm asking a question. Is it correct or not?
No, my lord, that cannot be, my lord, because the
So
bill.
supposing, let me ask you something. Supposing there is a house with two bulbs. Now that will have a multiplying factor wherever electricity is consumed multiplied by MF, correct? Supposing there is another house 20 kilometers away having 1000 light bulbs. Now that will the multiplying factor for that 1000 bulb lighthouse be the same as the multiplying factor for a two bulb for a two bulb house?
Lord, that is why the provision is for entering into contract related demand. That provision
This is
in
a
for-
simple question
because
I'm asking you.
I can
You
use
don't want
only-
to answer this, I will not get it. There's no point, I think I've heard enough. There's no point you not trying to answer a question. A simple question. This is a very
Pardon?
simple way. It's either yes or no. Whether a two bulb lighthouse, a two bulb house, and a 1000 bulb house will have the same multiplying factor.
It may depend on the Milord CTPT set as well as the meter ratings of meter bill. That is, I will place the gadgets Milord, their own gadgets. That will depend on the meter which is provided, because there is a two-phase meter, three-phase meter, and ratings are different.
Okay, supposing both of them are using a two-phase meter. One is having 1000 bulbs, this house, and one is having only two bulbs.
Then the multiplier factor will be same, Milord.
Will be same.
Because yes, Milord, the connected load may, according to the connected load, I will use my electricity. The recorded.
So you mean to say a house having 1000 switches and a house having two switches, their multiplying factor will be the same.
Milord, they will classify, there is a classification, Milord, in the schedule of tariff. If the consumer is classified in a particular category, then
Supposing they are classified in the same category.
in that case, that will be same. Milord. In that case, the multiplier factor, if the same meter is provided, same CTPT set is provided, then the multiplier factor will be same. I will place Milord few judgment, few bills. issued by them.
Ifs are very important. If the same CTPT set is provided and if the,
Yes,
because if the capacity of the transformer increases, your lordship, what my learned friend is, we need to understand, the multiplying factor is equal. And their thing, understanding is, what I have understood is, since it is 1.5 more than 1,000, the CTPT set would have to have been changed and the multiplying factor would have been.
Actually, you cannot have, I mean,
Yes,
it'll be
it's
different.
exactly transformer, your lordship, in other words.
your lordship, I will place few bills wherein your
These
lordship
are
will.
technical issues which the operator
My lord, your lordship, my lord, your lordship may kindly grant me 2 days time.
No, no,
I will
no more,
place-
no time,
I
no
will
time.
place there.
No,
bills
no, no, sorry,
Tomorrow, your lordship
No.
may kindly fix it tomorrow.
sorry. Heard. Mr. SK Kejriwal, learned counsel for the petition. Also heard Mr. KP Pathak, learned counsel for the APDC. Question. The petitioner has put to challenge the final order as final assessment order dated 23/6/16 and the final assessment bill dated 23/6/16 by which where is that final assessment order and final thing?
The assessment order, your lordship, is at 71. Number 71. And the bill, your lordship, is at 74.
By which the by which it was found that the total connected load of 1507 kW was detected against the authorized load of 831.0 kW in respect of the petitioner's tea factory, is it? Tea factory,
It's a tea industry, tea factory.
tea,
Tea factory.
tea factory. Okay, hence, he was saddled with the bill amounting to rupees 43, 88, 400. The petitioner the petitioner's case is that he is engaged in the business of plantation, manufacture and sale of tea. The authorized connected electricity load in the petitioner's tea estate is 831 kW. Which is equivalent to 978 kVA. The transformer capacity of the tea estate is 1000 kVA. The petitioner purchased various equipment in the month of April 2016, but did not utilize the same. As he had applied for release of additional electricity load. However, instead of the APDCL according necessary approval for release of additional load, comma, the APDCL officials visited the petitioner's tea estate for routine checking, comma, wherein they noticed installation of various machinery system. The next para, the petitioner's counsel submits that the APDCL officials on seeing the equipment / machinery straightway came to the conclusion that the petitioner had exceeded its connected load, comma, without verifying as to whether the said machines were connected with the APDCL main with the APDCL. First, he submits that the officials thereafter prepared a checking report showing the total connected load of the petitioner's installation at 1507 kW instead of the actual connected load of 831 kW, comma, thereby alleging that the petitioner had exceeded the connected load by by 676 kW. Next paragraph. The petitioner's counsel submits that the inspection report is absolutely silent that the load detected was the metered connected. He also submits. No. He also submits that the petitioners, that though the petitioner's connected load was 831 kilowatt, comma, the petitioner's contract related demand for consumption of electricity was limited to 783 kVA. To stop. Next paragraph. The petitioner's counsel submits that in terms of the electricity bill dated 9/6/2016, which is for the period from 1/5/2016 to 31/5/2016. The meter reading details show that the RD is what? RD means? Huh? The recorded demand. Bracket RD. Huh? K bracket KVA was 0.52, which was less than the MD means, which was less than the maximum demand bracket MD and billing demand bracket BD KVA, which was 783 kV. He accordingly submits that when the electricity bill shows that there has been no use of electricity beyond the contract related demand of 783 kVA, there was no occasion for the APDCL to have come to a finding that the petitioner was in unauthorized use of electricity beyond his connected load. He submits that at the extension of load simplicity, without there being any actual use of electricity beyond the connected load, beyond the contract related demand or connected load, does not amount to unauthorized use of electricity, within the meaning of Section 126 of the Electricity Act 2003. Huh? No. Actually, there are two writ petitions. The other one slightly different on fact.
Facts are similar, even he has exceeded his connected load.
The connected, okay, right.
Connected load, transformer capacity and contract demand will be different. Otherwise, the cases are same.
Mr. KP Pathak, the learned counsel for the APDCL. Has made his submissions with the help of Mr.
Shantanu Bose.
Shantanu
Both
Both.
DGM, commercial and revenue.
DGM, commercial
And revenue.
and revenue, APDC. Comma. To the effect the consum, the tariff payable by a consumer of electricity would involve multiplication of the RD bracket KVA along with the multiplying factor. So he submits that the multiplying factor for determining the tariff payable by the petitioner was based upon the petitioner's connected load being 831 or 783, which one? It will be the contract related demand or the which one?
Connected 831.
It will be on the connected load of 831 kVA.
KW.
Huh?
KW. KW.
KW. KW, huh? Good stuff. However, as the petitioner did not inform the authorities, correct?
Yes.
Did not inform the authorities about the equipment slash machineries used, bought by the petitioner for making a amendment slash correction of the connected load of the T estate, comma, the multiplying factor for determining the tariff on the basis of the connected load was not applied. Good stuff. Next paragraph. The counsel for the APDCL further submits that the multiplying factor for determining the tariff payable on the electricity consumed by a consumer would depend upon the capacity of all energy consuming devices, comma, connected with the distribution licensee mains in the consumer's installation and which could be simultaneously used. So he submits that just because the petitioner did not use all his machineries simultaneously, comma, which would have shown that petitioner's consumption of electricity beyond the connected load did not mean that the multiplying factor would not be made on the basis of the connected load. Would not be made on the basis of the connected load, even if not used simultaneously. This no uh, no comma which is reflected in regulation 1.3 bracket Roman 5 small of the the Assam Electricity Regulatory Commission bracket Electricity Supply Code and related matters bracket close regulations 2004 comma first amendment bracket close 2007 hereinafter referred to as the 2007 amendment. Full stop. Next para. The Council for the APDCL has further taken this court through Regulation 5.3 and Regulation 5.A.3.2 bracket Roman B, which is to the effect that when there is a need to change the connected load, the same has to be sent by the consumer in writing to the licensee.
That is at 5.35.
I know. And that exceeding the connected load authorized by the supplier is generally to be treated as a malpractice. What else? That's all.
Yes, Your Lordship.
Next
Mere
one.
act of connecting the additional apparatus to the electricity mains constitutes the act of.
So did he connect to the mains?
Yes.
He submits that as the APDCL had connected, no, as the petitioner had connected his machinery, his newly purchased machinery. At page, where's that?
We have stated so in our affidavit, Your Lordship. That with at page number 5, Your Lordship, of our affidavit in opposition, paragraph number 10. In this regard, the defendant respectfully states that at the time of inspection of the petitioner's estate, the load was checked and it was found that the load of new extension factory to the tune of 600 kilowatt and the existing factory with modification to the tune of 907 kilowatt, total of 1507 kilowatt.
Page.
Page 5 of our affidavit in opposition. Paragraph number 10. Was connected with APDCL.
No, where is the machinery? You had shown me something.
Oh, that list, Your Lordship.
Yes.
That list, Your Lordship, is a part of the main petition. Page number 54, 55, and 56.
What have I said? No, such as. No, as reflected in. such as at page 54, huh? You take this in the chart, it is there 1, 2, 3.
56 as well. There are two factories, one for each factory.
Okay, new machineries which are reflected in annexure 6 of the writ petition. Whatever I said, just read the entire thing. As reflected to the main line of the APDCL. Main line
Electricity means.
to the electricity
Means.
mains. The electricity mains of the APDCL. Without informing the APDCL. And as the tariff paid by the petitioner was not determined by use of the appropriate multiplying factor, comma, the petitioner has been unauthorizedly, should be, has to be considered to be unauthorizedly using electricity. The next part, the learned counsel for the APDCL further submits that these matters had earlier been heard at length.
They were not heard.
No, huh?
They were not heard.
No, it was there.
The issue
Heard
was
heard in part and all it is there.
where an issue was framed as to whether this petition were maintainable. We were asked to submit the written arguments
Okay,
because the learned coordinate bench was then sitting in the division bench.
okay.
He chose to release
Okay,
the
okay.
matters.
The learned counsel for the APDCL further submits that as there is an alternative remedy available by way of
In section 127 of the electricity.
127 of the Electricity Act 2003, the petitioner should avail the alternative remedy available. Correct?
Yes.
Next. Acha, one thing, Mr. Kejriwal again, huh? The learned counsel for the petitioner submits that in terms of what is this? In terms of clause, what? What is this? Page 21, what is this? Mr. Kejriwal,
Look, this is schedule of tariff framed by
clause, which clause?
C
It cannot be C, this is subclause C.
and
Where is
E.
the main thing? Huh?
This is the application from 10th of April 2017.
Oh, this is not applicable there.
Perhaps it not be.
So this is same provision incorporated right since 2006, my lord. I will place other.
No, no. So this is C, clause is not clause C. This is a subclause C or something. Cannot be C. You cannot put
Milord, I am
bits and pieces. Okay, forget this. This is not of much
You also, my
importance.
kindly take up this booklet, their book. There is a category tea, coffee and rubber. It's 24 or 25 page number.
How does this E help you? Overdraw penalty. How does it help you?
Lord, this overdraw penalty will be levied if I consume my maximum demand recorded by the meter exceeds the contracting. Only in that case, I will be liable for payment of overdraw penalty at 3 times of the normal rate of.
But here is a different case. This is a different case. Correct. Mr. S.K. Kejriwal, counsel for the petitioner submits that in terms of clause E of HT category, Roman 7 dash oil and coal, of the schedule of tariff issued by the APDCL, with effect from 10/4/2017, comma. If the recorded demand is higher than the contracted demand in a month, comma, then fixed charge based on contracted demand shall be levied at 3 times the normal rate for the portion of demand exceeding the contracted demand. Full stop. It submits that in the present case, submits that in the present case, the recorded demand is less than the contracted demand. And
Is equal to the contracted demand.
is
Maximum
equal.
in this case, below.
No, it's not equal to, it's less than.
No, equals to
Recorded demand.
783.
Huh?
That is
No,
equals
no, recorded demand is no, recorded is 0.53.
Maximum demand is, recorded maximum demand is 783
Correct.
and my contract demand is 783.
Recorded demand may change depending upon the month by.
Correct, correct. Correct, that's what recorded demand, no, that's correct, whatever I said. If you find that my understanding is wrong, then you can go and this is my understanding. What have I said? He submits that, what did you say? I'll record, he submits that the recorded demand and the
My maximum demand
and
and
the
the
and the
contract,
maximum demand is the same.
and the contract demand is same.
And the contract demand is the same.
Maximum
Recorded
demand
demand and the contracted demand is the same, which is 783.
783 kV.
73 kV.
783 kV.
KVA.
783 kV.
KVA or KV?
KVA. KVA. Kilowatt ampere.
KVA. As such, there's no question of
It is not exceeding
Payment-
any meter load.
as such, there is no there was no as such, the electricity consumption did not exceed
The
any
connected load, the connected load.
did not exceed the connected load. He also submits that as there was no consumption of electricity in excess of the sanctioned / connected load, there was no unauthorized use of electricity in terms of section 126 of the 2003 Act, as has been held by the Supreme Court in the case of so and so reported in 2012 2 SCC 108. Next para. The learned counsel for the petitioner has also relied upon the order dated 8/10/2018 passed by the Assam Electricity Regulatory Commission in petition number 13 of 2018, wherein it has held that in case of a consumer equipped with the MD meter, MD means
Maximum demand.
maximum
Maximum demand.
MD meter. The licensee shall compare the MD reading with the contract demand, and if the load exceeds the contracted demand, then penalty at 3 times the normal tariff shall be levied as per the provision of the schedule of tariffs. Full stop. It further held that clause 7. This is against this is a reading of the commission's observation. It further held that clause 7.4.2 of the AERC bracket Electricity Supply Code bracket close regulations 2017 would be applicable when unauthorized use of electricity was detected by an assessing officer. Excess connected load could not be termed as unauthorized use, if the maximum demand record showed otherwise. Thus, the provision of 7.4.2 under the AERC bracket Electricity Supply Code right close regulations 2017 would be applicable only when there was no record of maximum demand measured through a MDI meter. We call the others. There you go. Better.
Page 39.
Next para. The learned counsel for the petitioner further submits that the office of the Electricity Ombudsman, Assam Electricity Regulatory Commission, in its judgment dated 25/9/24, passed in appeal petition number 2 of 24, had held that as per section 126 of the Electricity Act, it was the actual unauthorized use by the consumer which resulted in some benefit to the consumer, which was liable for a penal bill. Full stop. But there was nothing in the inspection inspection report dated 27/3/2015 to establish that the petitioner was found indulging in any actual unauthorized use of electricity resulting in any sort of benefit. As such, the Commission did not find any wrong on the part of the APDCL in not issuing any assessment bill on account of alleged malpractice. The Commission further held that, as per clause 5.A.4.1 of the Assam Electricity Regulatory Commission Electricity Supply Code and related matters regulations, 2004. As per the 2007 amendment, as per just say, as per clause 5.8.4.1 of the 2007 amendment. Penal bill could be sustained only if the metered excess unauthorized load was detected during inspection, but mere extension of load without any actual use cannot be penal. Again, as per clause 7.4.2 Roman 3 small capital A small b of the Assam Regulatory Commission Electricity Supply Code close regulations, 2017, as well as the judgment of the. I think this is not relevant. Cut this. Cut that part. Now you come to the main thing. I have heard the learned counsel for the thing.
Lordship, would your lordship require the judgments of the division bench and the?
Yes.
Yes, I have.
You put whatever judgments you have.
Primarily on two issues, the judgments are there. I'll just give your lordship.
Like what? You give how many judgments?
Because the entire judgments are there, it looks voluminous. Just a few important paragraphs, your lordship. For page number 23, your lordship. This is the judgment of Shiv Alloy Steel versus APDCL, reported in 2021 4 JLR 558. Page number 23. Page numbers are at the bottom of the page.
Yes.
Paragraph number 26. In the present case in hand, the petitioner challenged the final order passed in subsection 3 of section 126 of the Act of 2003, along with other consequential reliefs. The issues decided herein above shows that the final order passed under subsection 3 of section 126 of the Act also includes the one against unauthorized use of electricity, where there is an allegation of theft of electricity under section 135 of the Act of 2003. Subsection 1 of Section 126 of the Act of 2003 authorizes the assessing officer initially to raise the provisional assessment to the best of his judgment electricity charges payable by the consumer after the inspection. Subsection 3 of Section 126 of the Act of 2003 allows the affected consumer to be heard, and thereafter the assessing officer is required to pass a final order of assessment. In the present petition, as herein above taken note, the petitioner disputed the provisional assessment and the final assessment order on the ground that there were no cogent reasons, grounds to impute the petitioner for unauthorized use of electricity with dishonest intention. Accordingly, issues raised in the petition are factual in nature, coupled with the technicality of the metering system in the premises of the petitioner. Section 127 of the Act of 2003 allows any person aggrieved by the final order made under Section 126 of the Act of 2003 to prefer an appeal before the appellate authority prescribed under the said section. From the submission of the learned counsel for the petitioner and on perusal of the averments made in the petition, I do not find in the averment showing that there was jurisdictional error while passing the final order against the provisional assessment made by the assessing officer. If there is any apparent jurisdictional error, there is no point in sending the petition to appellate forum, inasmuch as that will be a mere waste of time. In view of the said discussion, in my considered opinion, in the present factual matrix, which requires technical expertise for a decision in the issues raised in the petition, the petitioner is required to file an appeal under Section 127 of the Act of 2003 against the final order dated 7/7/2001 passed by the assessing officer. And your lordship, this judgment was upheld by the division bench. That your lordship will find the relevant portion of page number 35, the order of the division bench.
35.
Page number 35. This was writ appeal 286 of 2021.
Yes.
Paragraph number 9, your lordship. After considering the rival submissions of the parties, we have the opinion that presently the remedy available to the petitioner stroke appellant is an appeal under Section 127 of the Electricity Act, where he'll have liberty to place all his points, including whether due process under Section 126 has been adopted or not, and whether the quantum of assessment is in order. As a statutory remedy of appeal is provided to the petitioner, we are in agreement with the opinion of the learned single judge that the petitioner stroke appellant should approach the appellate authority first for dismissal of his grievances. The rest of the judgments, your lordship, because when I raised this issue next on the previous occasion, when the coordinate went, and a prayer was made from the other side that the statutory deposit requirement for making a statutory deposit should be relaxed. The rest of the judgments are on that issue, because in some cases, on depending upon the factual circumstances, it has been relaxed. But your lordship, of a coordinate bench, which I found later after preparation of the written arguments. I'm just handing over a copy.
Out here, it has been relaxed.
It has the law. The legal position is that since it's a statutory requirement and a legislative mandate, because appeal is not a right, your lordship, it's a creature of statute. So since the appeal statute has mandated that 50% has to be deposited, and that is the mandate of this law, it cannot be relaxed.
No, but okay. The division bench didn't say anything about it.
On this aspect, no. But in this judgment, the coordinate bench has held. At paragraph number 13, your lordship, at page number 4 of this judgment, the legislative intent is clear that no appeal against an order of assessment under subsection 1 of Section 127 shall be entertained unless an amount equal to half of the assessed amount is deposited in cash or by way of bank draft with the licensee, and documentary evidence of such deposit is enclosed along with the appeal. An appeal filed without complying with the requirements of Section 127(2) of the Act of 2003 cannot be adjudicated upon or decided on merit. There is no provision also empowering the appellate authority to dispense with or waive the requirement of deposit of 50% of assessed amount. Therefore, the argument of so and so an appeal filed without complying with the preconditions of such an appeal is also to be considered as an appeal pending for adjudication, and therefore the authorities are precluded from taking any coercive steps, cannot be accepted in the considered opinion of the court. Disconnection notice that so and so was likely. So, and some other judgments on similar lines I have enclosed. The lordship desires I can give the paragraphs. They are all on similar lines. But
We have not mentioned the paras.
because I did not mention the paras in the note, I can give your lordship the paras in the page numbers. The first judgment on this issue, your lordship, is 1988 4 SCC 402,
Para.
paragraph number 8 and 9, page number 48. This is on the point that appeal is a creature of statute. What the Honorable Apex Court has held, your lordship, is at page number 48, paragraph number 8. The aforesaid observations in our opinion have no application in the instant case. Here, the right that was granted was a right held with the condition. There was no question of a change of that right. In the instant case, the only substantive right is the right of appeal as contemplated under section so and so and so and so of the Act. And that right is a conditional one. The legislature in its wisdom has imposed that condition. No question of whittling down that right by an alteration of procedure arises in this case. Right to appeal is neither an absolute right nor an ingredient of natural justice, the principles of which must be followed in all judicial and quasi-judicial adjudication. Right to appeal is a statutory right, and it can be circumscribed by the conditions of the grant. And recently, your lordship, a matter was heard by a coordinate bench, your lordship, where the petitioner was again claiming that this requirement of a statutory deposit should be waived. The coordinate bench in the judgment of in WPC 529 of 2022, judgment rendered on 10/2/2023 has again rejected it, your lordship, and that has been upheld by the division bench. But the division bench, what the relaxation, the judgment of the coordinate bench, your lordship will find at page number 58, your lordship. The first paragraph number 22, section 127(2) lays down a mandatory condition for pre-deposit of a percentage of the demand. In the instant case, it appears that the only reason for which the appeal is still pending is non-deposit of the statutory amount. The aforesaid fact is not disputed. A careful examination of the pleadings made in the petition show that the writ petitioners are not aggrieved by the aforesaid provisions requiring a pre-deposit. Further, the virus of the said provision of law is also.
Okay,
And the division bench, your lordship, allowed them to pay the amount in installments without relaxing it.
Lord, I have also annexed a judgment below, which is at page 40. Relevant page is page 45, paragraph 12 of the Supreme Court. Paragraph 12.
One thing also right, huh? Mr. S.K. Kejriwal has further submitted that there is no bar for this court to decide the issue. And it is not an inflexible rule that just because an alternative remedy is available, the same has to be availed of. So in this regard, he has relied upon the judgment of the Supreme Court in the case of Srimati Har Devi Asnani versus State of Rajasthan and others, are reported in 2011 14 SCC 160. Okay, then that hearing concluded, judgment reserved for one, and for this other one,
Only the connected load and bill amount etc. will be different.
okay, tell me how much is the connected load?
Lord, the connected load in the first case is 418 kilowatt.
Just a minute, connected load is
418 kilowatt.
418 kilowatt.
And the transformer capacity is 500 kVA.
Transformer capacity is
500 kVA.
500 kVA and
The contract demand is 320 kVA.
contract related demand. No, what is it called?
Contracted demand.
Contracted demand,
is 320 kVA.
320
kVA.
kVA.
And in the first case, the final assessment order is at annexure J, dated 21/7/16,
Page,
page 44. And
final assessment order,
yes, Milo,
and
that is 21/7/16,
21/7/16.
and the final assessment bill is 21/7/16, that is at page 45.
Page 45.
The detected connected load, that will be important.
Huh?
The detected connected load will also be important.
How much is it?
The detected connected load is 840 kilowatt.
Detected connected load is
840 kilowatt.
840, that is excess of,
Excess
of,
418.
so that means come to 1000 something.
840.
This 840 includes this 418 or is separate?
It includes.
Yes.
Or includes?
Includes.
So total is detected on connected. Additional. of
According to
420.
them, the
additional
detected load is 840 kilowatt. So excess according to them is 422.
422. Does it will be the 400 will be subtracted from the detected.
So both.
Obliged.
Deeply obliged.
I put it here. I got all these matters. Yeah. This also. Thank you, Mr. Officer, thank you. Because we are still got to learn a lot. He is the only expert.
He is the
No,
expert.
So you see, so we are just ensuring that we are not taken for a ride.
question does not arise. I will refer only the provision.
No, because you see, the problem is if you keep silent on some issues, then we don't know where to go anyway. So that is why we need him, not because we are going to tell us you're taking up the wrong garden path, but you might be silent on some aspects. And that's where we could lose sight of the issues.
Also, I kindly consider one thing. This is out of these
Yes.
submissions. Whatever the submissions were made by my learned friend,
Ah,
recorded demand, multiplier factor, whether any bill is raised on that basis, no. So how he is making one submission which is neither in the pleadings nor reflected anywhere, my lord. He is making some submission, my lord, on the basis of which no bill is issued. The bill is issued on the basis of the excess load, extension of load simplicity, without there being any use.
No,
So
that you see, he made the submission due to the query raised by this court. This court had asked him, would there be a change in the multiplying factor if the connected load was higher? That is why I've given you that example of 1000 light bulbs in a house and 2 light bulbs in a house. So these issues cropped up from the court.
Lord,
I understand your problem.
Lord, so far multiplier factor is concerned, my lord, TOD tariff is applicable. My learned friend and the officer will admit, time of day tariff is applicable. Normal hour, peak hour, night hour. Different rate of tariff is applicable. Your lords will find from their bills. Different rate of tariff is applicable because if I use electricity in night hour, then the rate of tariff will be different. If I use during peak hour, it will be highest. And if I use during normal hour, then it will be made.
No, that is all right. That will apply for everybody.
Yes.
But then beyond that, there is also a thing called the multiplying factor.
Multiplier factor is multiplied with the recorded demand.
Recorded demand,
Yes.
but on the basis of the connected load.
No, my lord.
Huh?
That is on the basis of the maximum demand reflected, whether it exceeds the.
No. So you see, it's like this. Supposing your connected demand is 100. Your bill comes, multiplying factor is used on the 100. Now, is calculated as per the 100. But actually, supposing your connected load was 1000, then the multiplying factor would have been different.
Your lordship may kindly understand this thing for with an example.
Hmm.
Suppose I have 1000 kilowatt.
Yes.
During 30 minutes,
Ah.
I am using the entire 1000 kilo. Then as per the table given in the supply code, my lord, my total consumption will be 200 multiplied by 1000 kilowatt. But if during 29 days, 23 hour and 23 and a half hour, my consumption is nil, then meter will not reflect anything. Because meter records only the highest maximum demand.
No, there will always be a minimum bill payable.
There is
So,
no,
okay.
no minimum charge. Only I am required to pay fixed charge for the contracted demand entering to buy.
So the fixed charge is there.
Second tariff is on the basis of the unit consumed by me. Two-part tariff. One is the unit consumption and the other one is the fixed charge, which can be called minimum.
Okay, so fixed charge, there will not be any difference in the tariff if you don't use it, if you don't use it.
Then also I am liable to pay fixed charge.
Yes, you'll be
for
paid
the
fixed charge,
connected-
but the fixed charge will be again on the basis of the connected load also. I
Yes,
think.
so that is will be on the basis of the contract demand or the maximum demand, whichever is high. Either the contract demand or the maximum. If the maximum demand recorded is higher than the contract demand, then I am liable for penalty, overdraw penalty. That is how this has been designed.
But yours is beyond that contractual, the contract demand and the connected load also.
That is not reflected in the meter. That is why my
No, no,
entire case is that
there is no question of being reflected in the meter.
it is
Because
it is
and because it is only, you see, unless you use all your machinery, it will not show. When you have, say, you have got 20 light bulbs here,
your lordship.
but you're using only 10. Then then it will never cross the connected load.
Their own authority has interpreted the provision. I have placed two judgments. One judgment is already included.
So that is why better for you to go, let it go there. Otherwise, I might interpret it wrongly.
In that case,
So it will help you. If their authority, they're going to help you in the case, you go there. Why you want to take a risk with someone who is just learning the ropes? They are the experts.
in that case, my lord, my respectful submission before your lordship would be, there are judgments, my lord, of the Honorable Apex Court as well as our High Court. I have already deposited 25%. Pursuant to the interim order, there should not be any further deposit.
No, I cannot say that. I don't know.
That has been held by our High Court. There are judgments of our High Court.
Maybe, but then just because when the law says something, can this High Court change the law?
This 2011 judgment also says there was a requirement of deposit of 50%, my lord, in that case. If the demand is exorbitant, because as per the provision applicable, it is only the penalty will be applicable only if the metered load is found excess. There is nothing, my lord, in the bill or in the document prepared by them that my metered load was found exceeding the authorized connected.
Anyway,
In
let
that
us
case,
see.
this
Let
demand
us
is
see what happens. Nothing is sure. Let us see what happens. Anyway, thank you both. I've become a little bit wiser on how the electricity bills are made. Though very technical. Very technical. Kejriwal will be knowing. The judge he doesn't even know half of what I have forgotten. He'll be saying that. Anyway, let us see what happens. That's our job. We've got to do the best we can. Only one thing that tariff, the multiplier factor, that has to be calculated in terms of the connected load. Can you give me the book or some booklet or something, you've got a schedule, you've got some, you can make a photocopy of it if it's not too thick, you can give it to the council, you can give it to me. So that I understand, say connected load for say 500 kV, the multiplier factor will be this much. For 1000 it will be this much, for 2000 it will be this much, for 3000, if you can show me that.
Lord, I will give the literature.
Oh, yeah.
I will supply the literature.
Both of you can
Tomorrow,
give. Either way,
Tomorrow.
either.
as well as their bills, my lord. I will show, even if the connected load is 3000, the multiplier factor may be 1000. I can show from their own bill. It depends, that is what I have submitted, my lord.
My
It
lord, what
depends.
he is trying to say is, he is actually, I think that it is a misleading statement. Suppose if I have a rated CTPT set installed in my premise, so
CTPT?
CTPT
Yes,
set.
that is what I have submitted.
Uh,
That's what, please make it layman's terms. Please say transformer, we understand that, yes.
My lord,
Yes.
question is, suppose a CTPT set is installed in my premise. So it has a rating of 300 by 5, suppose. So 300 will be the maximum current in his primary coil, and secondary coil will reduce it to 5 ampere and will send it to the meter.
Okay.
Meter will read accordingly as if the network is consuming 5 ampere current. That is why we need to multiply it by again that 500 by 5, that means 100. So that with that 100 we need to multiply it to get the actual consumption, because meter is recording the reduced consumption.
So if the conducted load is high, the transformer has to be able to match that.
Yes. If I have, sir, in that case, suppose 831.
Correct. So if he's got the transformer for 1000 kV, KVA.
1000 kVA.
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 If he's got a transformer 1000 kVA, his connected load should be at least till 1000 only.
Yes.
It cannot be beyond that.
Without upgrading, suppose I have a cable.
So it will be 1000. So if it is 1500 connected load, then transformer should be 1500, and that ampere, if it's 5, so 5 into 1500, it'll come. Correct.
Pardon, I didn't get your point.
If the transformer is say 1000 into 5, say 1000, the load is 1000, and it gives electricity of 5 amperes.
Current transformer.
Yes.
Okay.
But so that will only give current of say 1000 kVA, correct?
Yes, 1000. Suppose if the transformer has 1000, I mean, the CTPT set has a rating of 1000 kVA. So that is the actually production, I mean, multiplication of voltage and current both. So this is a little bit complicated, but for now, I just want to keep it as simple as, suppose a meter has its own current carrying capacity, and the actual current which is flowing in the 11 kV feeder is much higher.
Correct.
So how the meter will read now. Suppose if the main APDCL main is providing 300 ampere current, but the meter has a bearing capacity of maximum 5 ampere. So I will have to reduce that 300 to 5 and will have to inject it to the meter so that meter reads it accordingly.
Correct.
Then when while calculating the actual or for getting
Actual
the actual
usage.
figure of consumption, I need to multiply it again by the same ratio so that I can get the actual.
So if the transformer is 1000 kVA, and you're supplying from there, you are making it into 5 ampere current and supplying it to the T estate. Then when the electricity bill comes, whatever that into 1000. Correct.
The consumption which is coming in the meter, that has to be multiplied by the
actual multiplying
Whether
factor to get the
connected load or the
consumption.
contract
Yes, to
load or
get the
whatever.
consumption, yes.
Huh? With the consumption or with the load, with the connected load or the contract load?
Sir, as my friend said that this is a two-part tariff, no? So, Your Honor, two-part tariff means, so one component is fixed charge, another component is energy charge. Fixed charge is something which a consumer has to pay whether he uses
Or not.
electricity or not. And energy charge is the whatever consumption is recording in the meter, so kWh. So on that basis, the energy charge will be billed. And so we are talking here about fixed charge, the loss in fixed charge which which APDCL is incurring due to non-regulation of excess load installed by the consumer unauthorized.
Correct. Okay, so this is loss due to fixed charge.
Yes.
No, but my question is that multiplier factor. Say it is, forget fixed charge. I'm talking about consumption. Supposing there was usage of electricity. So the multiplier factor will depend upon, so they will depend. Correct? If there is 100 bulbs in one house and one bulb in another house, the multiplier
Factor has to be upgraded.
will be different for the two houses.
Yes.
Correct?
Has to be upgraded.
So do you have a booklet on that?
Yes.
That I want to copy that.
But what has fallen from my learned friend, my lord, the multiplier factor is used for the purpose of determining the kWh, that is unit. And there is no penal provision for realization of any unit charges. This is realization of fixed charges. So the very submission of multiplier factor, that is not applicable. That is not at all applicable in this case, because multiplier factor is used to determine the recorded demand multiplied by the multiplier factor equals to the unit consumed by the consumer, for which the unit charges is payable. We are not concerned with the unit charges. There is no demand. Demand is on account of fixed charges, which is not relevant for the determining the issue by taking into consideration the multiplier factor and the recorded demand. That is not the issue.
I would like to disagree because the recorded demand which is shown by the meter, that has to be multiplied by the MF to get the actual KVA consumption.
But you are using the electricity.
If I use
But the equipment that was not connected to your thing, to the, it was not, I mean, the load was not corrected. The
Yes,
connected load was not.
connected. That is why I am not using. They have simply noted down the rated capacities, because had it been used, that would have been reflected in the meter.
You must have taken it out.
No,
At that time.
they will make inspection, surprise inspection. They are not giving any advance notice, though there is a provision for issuing advance notice. They are never giving any advance notice, because if advance notice is given, my lord, I will admit, then the consumer, if he is indulged in any unauthorized use, he will remove it. So that is why the inspection is surprise inspection. I am not disputing that money inspection is it, but no prior notice. They are not issuing any prior.
If there was no requirement from the consumer's end, then why did they install such there was a load of 637 kilowatt found in excess over and above the connected load. If they were not using that load, then why did they connect that huge amount of load to the APDCL network without the permission of
They have
APDCL?
connected it. They have connected it. For sure.
For sure, sir.
Anyway, thank you.
DPW.
Okay, on the last occasion, we are supposed to give the review number.
Yes. Review petition. Filing number is there.
Yes,
It's not listed.
it's not listed.
You filed it on 3/10/2024. And this order was passed on 24/9. That means on the date you made the submission in the court. This was not in existence. So you have told a lie to the court, blatant lie.
No, Lordship, there are many reviews, Lordship, around 150.
Maybe,
Reviews.
maybe, but we are concerned only with one review. There are thousands of reviews all over the country. What? Thousands, lakhs. We are not interested in all of those lakhs. We are interested in only one case. List this matter, have this listed. We'll fix it. Right, Miss D Jane appears for the, no, Miss, D Angan appears for the petitioner, while Mr.
Sharma, Lord.
T Sharma appears for the Water Resource Department. In the last order dated 24/9/24, the counsel for the Water Resource Department had stated that review petition has been filed in WPC 4734/2021. Full stop. Mr. C. Sharma has produced the e-file, the filing, e-filing document issued by the registry of this court, which shows that a review has been filed on 3/10/2024, while filing number 12017/2024. The above clearly goes to show that the counsel for the Water Resource Department had not been truthful in her submission on 24/9/2020.
Lordship, there are many reviews, so we are processing it, so it must have been left out.
Okay, the above being said, registry to list the review petition which has filing number 12017/2024 on Monday, along with the presented petition, along with the contempt petition.
Publish it.
Sixteen.
My lord, pursuant to order 27/8/2024, my lord, APDCL were directed to produce, my lord, the records, original records, my lord, with respect to Annexure 6, my lord. That is, there is a letter, my lord, on serial number. This is a non-payment of contextual dues, my lord. The work orders, my lord, that were issued on 1996, my lord. So we need some time to trace the record, my lord. So whether this work order.
Mr. Counsel, is August. Orders passed in August.
Yes, my lord.
Now it's September, October, 2 months.
Yes. 3 weeks more. My lord.
Huh? Who do we call? Which officer should we ask him to bring? The executive engineer or what?
My lord, perhaps the executive engineer, my lord, the PO. But as of now, my lord, we'll try to trace it out and ask them to bring the record, my lord. If not possible on the next day, my lord, then they may be called.
You see, because this okay, right. Mr.
Bidas,
Huh?
Bidas.
Bidas, Senate Counsel for the APDCL. Pays for one last chance to produce the records. In terms of the order dated 27/8/2024. This is the matter on when?
My lord, third week of November.
Too far. 12th,
12th October.
this is a matter on 12th. Pairing which the concerned executive engineer may be asked to produce the report personally.
Probably.
20 and 21.
Applicable. Lots of matter may be fixed on next week, any date, your lord.
This is not payment of what? That performance security,
Yes, sir.
Mr.
R.M. Mazumdar.
R.M. Mazumdar
Yes, your lord.
appears for the petition
On behalf of D. Hussain.
on behalf of Mr. D.O.C. No one appears for the respondent. According to this matter, when
Any date, your lord.
this matter after the week.
Public.
Item 22.
So here the if petitioners challenge the order passed by the EPFO tribunal, by which the tribunal, without having any jurisdiction, reduce the penalty towards the EPF, and that too without by misinterpreting the provisions of law. That's a lordship needs some hearing. Lordship here, I mean, today may not be possible.
Today not, I've got one meeting also.
Lordship fixes some other time.
But leave this matter on
12 November.
12th?
November.
Huh? 14th.
No, let it be before that, but November 12th.
Lordship,
12th.
Lordship, I have a submission of in this matter.
Huh?
Escart Bank related matter. Lordship.
Huh?
This one is Escart Bank related matter. Lordship,
So?
this Escart Bank is completely stopped, Lordship, functioning. Some of the cases, Lordship, in the pending before this honorable court, Lordship, there are so many cases. All cases taking part are by the honorable justice.
No, that is a different matter.
And any matter, Lordship, if any issue, Lordship, relating to the Escart Bank, Lordship, the Advocate General, Lordship, is appearing for resolve this issue only, Lordship. Either
I'll leave
bank.
the matter on 12th.
Yes.
Leave it.
Okay.